May it please your lordship. But may I have your lordship's kind indulgence to mention item number 41, my lord. Actually, we are appearing for the private respondent. Today we have entered appearance, my lord. Item 41.
Yes.
Lord, I would pray if it can be taken up on Wednesday or Friday. my lord.
You're for the
And for the
petition.
private, we intend to file a small affidavit. my lord. Today we have entered appearance.
So let them appear, lordship, no objection to that. So let the matter be taken up on Monday next, because Friday and Wednesday I am not in Guwahati, lordship. So on Monday next.
Who is for the petitioner?
I am for the petitioner, and interim order is there that may be extended till Friday,
Okay,
Monday,
you're for the petitioner.
lordship.
My lord, in that case, it can be taken up on 3rd. Monday, I may not be there. my lord.
Yes, lordship. Third I am available, lordship.
Thursday.
But Thursday. Anyway, my lord, this is only miscellaneous week. The last week is a miscellaneous week.
Ah.
Thursday, I think Friday.
There is one bit left. One bit. Here's a single bit. You'll be relying on justice judgment, I think. Devin Das.
We will have a parting gift, lordship. My fan.
Okay, right. On the prayer of the parties. On the prayer of Mr. D. Saikia, Leonard
No,
Senior
no,
Counsel.
on the prayer of them, lordship.
Okay,
Not-
on the
we are not
prayer of
seeking
Mr.
time.
K. Chowdhury, Leonard Senior Counsel for the respondent number 5,
Six.
who submits that he wants to file a affidavit in opposition. List the matter on 3rd.
Highly obliged, lord.
Interim to court.
Interim order to continue to the next week.
Till then, my lord.
Deeply
Till the
obliged.
next week.
Yes.
That is your lordship. My lord, I beg your lordship kind indulgence in the matter, my lord. To very urgent, my lord, to be taken at 2 p.m. My lord, what is the urgency? I have filed by WPC number 1126 of 24, my lord. What happened, my lord? There was an my lord bidding of lottery of selection of outlet, retail outlet of IOCL, my lord, in Karimganj district. I was selected, my lord, by lottery long before.
Provisional selection, probably.
Yes, my lord. Provision. Yes, your lordship is exactly correct. Then, my
No
lord, what
hurry, no
happened?
hurry. Provisional
My lord,
selection.
in the meantime, what happened, my lord? The same land is acquired by the government of India and government of Assam for Bharatmala and Assammala project for extending the road, for making it 4-lane, my lord. So, my lord, I offered the second plot of land that it is permissible as per my guidelines. My lord. But they have what have done, my lord. On day before yesterday, on 20th, my lord, I have found an online, my lord, notice, just names, my lord. The lot will be recontacted on tomorrow, my lord. Only on just I come on Friday, my lord. And on tomorrow it will be conducted, my lord, excluding me, my lord, newly, my lord. So only, my lord.
Excluding you.
Yes, my lord. I have no fault, my lord. I was selected.
Okay,
that
at 2 o'clock.
obliged.
My lord, item number 3, my lord. Here, my lord, I have got the instruction. I would like to file my affidavit, tender matter, my lord. Can it be on Friday or Monday, my lord? In the meantime, they may submit a reply, my lord, on a very short compass, my lord, the issue is there.
Who is for the petitioner?
He is for the petition.
Okay. Mr. B. Gogoi appearing for
PWD, my lord.
the PWD. What is this matter regarding?
It's regarding cancellation of a tender, my lord. Of a technical bit of the petition.
Appear for PWD, submit that he'll be filing an affidavit within
By tomorrow, I can file it.
by tomorrow. Accordingly, leave this matter on
On Monday or
Monday.
There is a assurance given by the PW that may be complete.
no, it won't be, my lord. Work order will not be issued, my lord. It's already there.
Okay, Mr. Mr. B. Gogoi submit that no work order will be issued in the meantime.
Yes. Around that.
May it please your lordship, I'm praying for listing of a read petition tomorrow, lordship.
New matter, old matter, what?
New matter, lordship, motion matter.
What is the agency?
Lordship, the private respondent declared as a valid bidder despite being many shortfalls in his technical bid, lordship.
Petitioner.
No, the private respondent, lordship.
And your technical bid is qualified.
Yes,
Okay, tomorrow.
obliged.
Please, my lord, with the concern of the petitioner, my lord, I beg to mention item number 31, my lord.
Yes.
I pray for some time to file our affidavit in opposition, my lord.
You are for whom?
I am for the respondent APDCL, my lord.
APDCL, okay. Who's for the petitioner? Okay, right. Mr.
B Das, my lord.
B. Das appearing for the APDCL. is granted.
My lord, 2 weeks time, my lord.
2 weeks time
Just
to
after
file.
the opening of the.
Huh? Is granted 2 weeks time to file affidavit of position. This is the matter after the vacation. It is in order to continue till the next week.
But you cannot date be fixed, my lord.
Give a date.
20, my lord.
Huh?
28 years.
28. Okay.
I'm obliged.
Make is your lordship. My lord, in SP item number 14, my lord. Here, my lord, the term of settlement of fishery has already been expired, my lord.
Okay.
It was for 7 years, my lord.
So,
So of that count, my lord, the petition may be closed.
Mr.
RM Dekra.
R.M. Dekar, learned counsel for the petitioner, submits that the petition has become infructuous inasmuch as the settlement period of 7 years has ended during the pendency of this case. The prayer of the petitioner, right, in view of the submission made by Mr. R.M. Dekar, the writ petition is closed as infructuous.
Deplog.
May I plead your lordship, WPC 5061/2023. It may be taken before any date before the vacation.
Give a date.
May I plead your lordship, lordship, item number 22 and 23.
This,
Lordship, the matter is infructuous and
okay. Miss
C. Sharma,
C. Sharma appearing on behalf of
P. Monta.
P. Mahanta, learned counsel for the petitioner. Petitioners submits that the writ petitions have become infructuous. Who appears? Yes, Excise Department. Excise. Here for the excise.
Ask one of my colleagues to appear, Lord.
Who? We just give his name. Mr. D. Gogoi appears for the Excise Department. In view of the submission made by the petitioner's counsel, the writ petitions are closed as infructuous.
Item number 6, my lord. You have an order that about that NFS, yeah, my lord, that lifting of the food grains. So last time it was, my lord, listed in the court, honest council asked for the, my lord, instruction. In the meantime, my lord, they have already allotted to the third part.
So,
So new cause of action has
so
come.
it becomes infructuous.
So we may be allowed to with a divided.
Withdraw. Okay, right. Mr. H.R.A. Chowdhury, learned senior counsel for the petitioner, submits that the writ petition has become infructuous. And actually accordingly prays that he may be allowed to withdraw, no, submits that he may be allowed to withdraw the writ petition with liberty to file a claim. As a new cause of action has arisen. The prayer of Mr. H.R.A. Chowdhury is allowed. Writ petition dismissed as infructuous, with liberty as speaker.
May I please, your lordship, the item number 18, lordship.
Yes,
The password for the lordship, our file is could not trace out, lordship.
here, but then the problem is
Tomorrow,
not your file, the problem is with the
Lordship,
number.
tomorrow, lordship.
Huh?
Tomorrow,
I don't want to read again.
day after tomorrow, lordship.
You wait. You wait.
May it please your lordship. This is a contempt application. The order is at page 74.
Okay, right, heard Mr. A. Sharma, learned counsel for the petitioner, who submits that the order dated 11/3/2024 passed in WPC 1545 of 2022 has not been complied with. First off, he submits that the above order has been made in pursuance to the order dated 13/1/2022 passed in IA Civil number 139 of 2022, wherein the state government was to release 30% share of the rupees 143, of rupees 143 per quintal of rice. Issue notice returnable in 5 weeks. The petitioner shall take steps for service of notice upon the respondent number by the sole
One
respondent
sole respondent.
by registered post with AD within 2 days. Leave the matter after 5 days.
Oblige your lordship.
Lordship, we have filed an affidavit. The matter relates to non-payment of contractual dues. There is a civil dispute as well. Lordship, at page 39, the issues that are relating in the related in the civil disputes are there in page 39. It was regarding a bank guarantee, Your Lordship. The contention was that the contract was not completed within the stipulated time, and as such, the bank guarantee was
So according to you, the contract is completed,
completed.
and according to them, it's not completed.
It's completed, but beyond the time that was permitted, because the work completion certificate was
so-
also issued.
So it is not completed within time. So that's why you have got to pay penalty. That is their case.
That is there.
So
And that's why the bank guarantee was revoked.
now admittedly, it is beyond time.
Lordship,
What remains then?
in paragraph 9, Your Lordship, of
No,
the
no.
petition,
Tell me something. You are supposed to complete a contract within a particular period of time.
Lordship,
It is not your case that you have completed within time.
No.
You have admitted that it is beyond time.
beyond time.
Now, it is also not your case that you have been given extension of time.
We were given extension.
You
because
have
the-
given extension.
in the judgment of the lower court, Your Lordship.
No, I don't want judgment of the law. I want, show me here, where is your extension of time in your affidavit? Show me the document.
The work completion certificate is there, Your Lordship. It was completed.
Mr. Counsel, there's a very simple thing.
The extension-
Whenever extension of time is required to be given, an application is made by the contractor. And the other side, they give the thing by way of a written document, unless it is verbal. Now, where is that written document?
Lordship, I may be permitted to file another affidavit.
Mr.
BJ Mukherjee.
BJ Mukherjee, learned counsel for the petitioner, submits that he would like to file an additional affidavit showing the extension of time given by the state respondents for completing the contract work beyond the stipulated time period for completion of the contract. work. This is the matter after
2 weeks.
2 weeks. Yes, what is this?
GDNT has been done.
Is there any FIR?
No FIR.
Then why?
Because my tax was found
Huh?
tax was found
Drugs.
Yes, my tax.
Drugs are found.
Tax,
Huh?
Tax vehicle, madam.
I know truck was there, but why have you detained it? What is the reason for detaining it?
Not detained, my lord. There are two truck, my lord. One truck was, my lord, they are trying to unload from Gutka from one truck to another, my lord.
Gutka,
Gutka.
from one truck to another. So what is
One
wrong?
truck to another.
Huh?
One truck to another.
So what is wrong? Let them unload. What is wrong?
In the middle of the night, my lord.
So
Then
what?
Then, my lord, when.
They have to do it in the afternoon or something. There's some timing.
No, my lord. VDP, when VDP party opposed, my lord, they left, my lord.
When VDP party approached them.
And they informed the police station.
So,
And
but you tell me, what is the wrong? What is the illegality?
in the middle of the, my lord,
Middle of the night.
middle of the night.
No one-
in the
no one-
highway,
no one-
my lord, in the highway, my lord.
Everyone has to sleep in the middle of the night. You cannot do anything, huh?
Without there being an FIR,
Huh?
without there being an FIR,
Is there any seizure memo given to them?
no,
No, see, my lord, no FIR has been registered, my lord, only because, my lord, GDN, making the GDNT, my lord, pack was kept in the police station, my lord. But nobody opposed the authority also, my lord.
No one has approached the authorities for Zima.
we have given representations, my lord. Personally, we have visited, my lord. We have been assaulted. I have annexed the medical documents, my lord.
Okay. Bearing so and so, flying from hijacked. $28 bags of gutka.
Yes, my lord.
Okay, so whatever, that truck was hijacked by whoever. Now the owner is coming to take Zima, is it?
My lord.
Then what is wrong?
Yes, my lord.
What?
No FIR was, take is there no FIR.
There's no FIR, nothing. You have made a GD entry. Yeah, there's nothing here. You want only the truck or what do you want?
Truck.
You don't want the good car.
That is, we are not, owner of the vehicle is not the owner of the good car, my lord.
But it was found in your truck. It did not land there by magic.
We are only concerned about the truck, my lord.
Then you go to the authorities and take it.
Yes, my lord, with my
You direct-
documents, my lord.
Yes. That observation may be made, my lord, the petitioner is the owner of the truck, my lord.
Right. No, we do not know.
Yes, yes.
You go with your documents and let them,
After verification.
let them
yes.
verify. Heard Mr. P.K. Munir,
My lord.
learned counsel for the petitioner, and Mr.
And second,
M. Chettiar, learned counsel for the respondent. The petitioner is agreed by the seizure of his Ashok Leyland truck bearing registration number AS 25 FC 1547. What have I said? By the Dekia Julie Police Station on 10/3/2024. Without there being any case registered or any case or general diary entry registered or any general diary entry being made against the said truck. The petitioner's further grievance is that despite the petitioner having tried to have the vehicle released on Zima, the petitioner's request is not being entertained by the authorities in the Dekia Julie Police Station. Next paragraph. Mr. M. Chettiar, the learned counsel for the respondents, has submitted letter number crime/106/2024/5098 dated 19/9/2024, issued to him by the Superintendent of Police Sonitpur Test, which is to the effect that a general diary entry was made by Dekia Julie PS GDE number 14 dated 12/3/2024 in connection with the custody of the above vehicle. Next para. The general diary details dated, the general diary entry dated 12/3/2024, which is attached to the above letter dated 19/9/2024, states as follows at serial number 6 and 7.
No seizure memo have been handed over to us.
One thing, right, the petition counsel. No, the petitioner's counsel submits that no seizure memo has been handed over to the petitioner, who is the owner of the truck till today. Okay, then this, next. On perusal of the letter dated 19/9/2024 and the general diary entry made by the police, there is nothing to show that any case has been registered. Correct? Yes. Against the petitioner or the truck. The only thing that can be seen is that the truck was apparently hijacked and it was carrying gutka. The above being said, the petitioner who claims to be the owner of the truck is required to be heard by the OC,
madam.
by the OC of the Dekia Julie Police Station with regard to his prayer for releasing the vehicle on Zima.
Now, the documents pertaining to the vehicle, my lord, registration, insurance, all are in the vehicle itself.
Yes, sir. By verifying whether the petitioner is the owner of the truck vis-a-vis the vehicle documents which have been seized along with the truck,
But that is it.
Full
his
stop.
contestation.
which may have been seized along with the truck. Full stop. In addition to the above, comma, the petitioner should also produce documents which are in his possession to show that he is the owner of the truck. If that Vahan is there, you can always go into the Vahan portal.
Yes,
This can also be, the issue of whether the petitioner is the owner of the truck can also be clarified from the Vahan portal. In the event the petitioner is found to be the owner of the truck, and if no case is registered against the truck or the petitioner, comma, appropriate directions for release of the truck should be given by the OC of the Dekayajuli police station.
If we, a time frame maybe
The entire exercise should be completed within a period of 3 days from receipt of a application by the petitioner, no, from the petitioner, along with a copy of this order.
After satisfying that matter, he is the owner.
Actually, take to satisfy himself within 3 days. This petition is accordingly disposed of.
Regarding settlement of Bazaar matters.
Is there affidavit?
Matters in the
What is your case, Mr. Counsel?
matters, is the settlement of Bazaar matters.
Look, the way, the bazaar was settled with you for which date? For which year? 22, 23, correct?
Page 30.
23, 24.
24, 24,
Huh, page?
24 to 20, 2005. 15. 1/7/2024.
Which page, Mr. Counsel, which
Page,
page?
page 38.
38. Let us see, yes?
1/7/2024 to 36/2025.
No, you tell me, this page 38,
38.
this has been settled with you on the basis of an NIT? Is this on a basis of tender notice?
Yes, Millers.
Show me which tender notice.
Millers, in this case, Millers.
Show me the tender notice.
Millers, as per my instruction, I want to do the petitions, Millers,
Ah,
with the liberty to file a fresh ones if the situation is.
okay, let him withdraw.
They have given a
Mr.
circle.
H. A. Sarkar
Yes.
appears for the petitioner, while Mr.
I'm appearing on behalf of Mrs. R.D. Bora,
What is your name?
P. Hazarika.
Mr. P. Hazarika appears on behalf of Mr.
It's Mrs.
Mrs. R. B. Bora, learned counsel for? Huh? For the
Standing
BTC,
counsel.
for BTC. Anybody else? Ms. U. Das appears for? This point number 1. Mr. H. S. Sarkar, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to file a plea. First up.
If cessation has.
Uh, the prayer of the petitioner's counsel. No, before that, you're right. On perusing the writ petition, come on. This court finds that there is no document showing that an NIT had been issued for settlement of the Kata Jhar Goramar Bhat for the year 2024-2025. Comma, though a settlement of the said market has been made with the petitioner for the year, for the period 1/7/24 to 30/06/25. The above does not seem to be proper. In any event, as the petitioner's counsel has prayed for, withdrawal of the writ petition, with liberty to file afresh, the same is allowed, the said prayer is allowed. The writ petition is accordingly dismissed as withdrawn, with liberty as paid for.
Till 7.
Yes, what is this? CD,
Not you.
yes,
May I please your lordship? My lord, the petitioner is an MSME registered company, my lord. And there was an agreement between the respondent number 2 and respondent number 1. An agency agreement for execution of a particular work in Lakhimpur College. That is for laying the athletic track. Now, my lord, the entire job was completed. The completion certificate was issued. Now, in the meantime,
okay, we'll issue notice, heard Mr.
lordship,
B. Dave Leonard, senior counsel for the petitioner who submits that the contractual dues amounting to rupees 38,92,727 has not been paid to the petitioner despite completion of the work project. Despite completion of the work contract. By the petitioner, issue notice returnable in 4 weeks. Miss P. Bhattacharjee.
I am with him, Lordship.
Huh?
I am.
Oh, you're for the petitioner.
Yes, I am with him.
Issue notice returnable in 5 weeks. Petitioner takes step for service of notice upon the. Wait, who is for the government? The CGC?
National-
You can take for Jal Shakti,
My lord,
Mr.
MR Adhikari, MR.
MR Adhikari, accept notice on behalf of respondents number 3 and 4.
Yes, Lordship.
3 and 4. 3 is the Union of India. And
he is
the
Union of India, my lord.
petitioner to take step for service of notice upon the respondents number 1 and 2 by registered post with AD within 3 days. Extra list the matter after 5 weeks. Extra copies of the writ petition be provided to Mr. MR Adhikari by the petitioner's counsel during the course of the day.
Obliged.
I'm deeply obliged. my lord.
May I please your lordship? My lord, this case, my lord, NIT was issued, my lord, my lord, 5/6/2024 for settlement of several fisheries. My lord, including the present, my lord, fishery called the, my lord, Kedinala Sunari Ghat.
Who are you right now? You have got no right to this fishery.
My lord, I am an intent, my lord, there is an order from this honorable court to settle the fishery, my lord, the government fishery. So I'm an intending, my lord, the participant there, my lord. And on the last occasion also, my lord, similar, my lord, the approach, my lord, lordship had stayed the thing. Now, my lord, thereafter, the writ petitions were all disposed of. Holding, my lord, the missing autonomous council doesn't have
Right.
an authority. Now, my lord, without any reference, my lord, to the tender, which was, my lord, the NIT, which was, my lord, earlier stayed by this, by your lordship, my lord, they had issued this impugned order, my lord, at page, my lord, 87. My lord, it's a, after knowing that this there is a stay order from this honorable court, page 87, madam. And my lord, our case is that this particular fishery also falls within, my lord, the Brahmaputra Part 4 fishery, which is a government fishery, my lord, where there is a direction to settle, my lord. Now, if this kind of settlements go on, my lord, then the settlements of the, my lord, by the government is affected, my lord.
Where is the stay order?
Stay order, lordship will find page 82, my lord. Lordship had stayed, my lord, all the fisheries from serial number 1 to 53 and 59 to 55 to 59. This is a 36, serial number 36, my lord, of the impugned NIT.
So one, and this one is 36. So it's covered by this order.
Covered by, so no, in fact, the writ petitions are disposed of, my lord.
Huh?
Writ petitions have been disposed of finally. Holding, my lord, the missing autonomous council does not have any authority to settle any fishery.
Correct.
The covered case also.
Huh?
Already covered also.
Correct. So we'll set aside this
Right.
settlement of the Mean Mahal.
Right. Page number 90 is the order.
Page number
90.
90. Correct. Right. Okay, right. Heard Mr. M. Datta, Learned Counsel for the petitioner, who submits that the missing autonomous council has issued NIT on 5/6/2024 for settlement of 58 fisheries amongst others. No, for settlement of fishery listed at serial number 36 amongst others. With the KD Nala to Sonari Ghat Meen Mahal with the respondent number,
Five.
respondent number 5 for a period of 2 years with effect from 1/7/2024 to 30/6/2026. So he submits that the said fishery overlaps the Brahmaputra Part 4 fishery, which is at serial number 36 of the NIT dated 5/6/2020. Ms. Farah, the petitioner's counsel submits that the NIT dated 5/6/2024, which overlapped Brahmaputra Part 4 fishery, was put to challenge in WPC 3156 of 2024, and that this court had stayed the NIT insofar as it was in relation to Brahmaputra Part 4 fishery and other fisheries and some other fisheries in the NIT.
No, well, Brahmaputra Part 4 fishery is not in the NIT.
Okay,
Brahmaputra Part 4 is being overlapped by these settlements.
Acha, is not in the NIT.
No, no. Brahmaputra Part 4 fishery is the government fishery,
Uh-huh.
and which these fisheries will are overlapping.
And
So
that's what, that 36 is overlapping.
36.
Uh-huh. What have I said? In as much as it overlapped, in as much as serial number 36 of the NIT overlapped Brahmaputra Part 4 fishery.
Exactly.
So, he submits that. Subsequent to the stay order passed by this court on 21/6/2024 in WPC 3156/2024, the missing autonomous council bracket MAC in short have settled the fishery at serial number 6 of the NIT dated so
36.
Huh?
36.
36/2024 with the respondent number 5.
No, no, no. Serial number 36, not 6.
That's what I said, serial number 36.
And NIT is dated, order is dated 29/6. Impune order is dated 29/6.
No, just a minute. NIT dated 5/6/2020. Then whatever I said, just read that. I got lost. Which overlaps the Brahmaputra 4 fishery, which used to be settled by the government of Assam. Wide letter dated 29/6/2024, issued by the Principal Secretary, MAC. The petitioner's counsel submits that in view of the judgment of this court in WPC 3065/2024, the settlement of the KD Nala to Sonari Ghat Meen Mahal with the respondent number 5, provide the letter dated 29/6/2024 issued by the Principal Secretary, MAC. It is not sustainable and has to be set aside. Next paragraph. Mr.
D. Gogoi.
G. Gogoi.
D.
D. Gogoi, appearing for the MAC. And Ms. Yudas, appearing for respondents number 2 and 3, submit that the present case is a covered case in as much as the in as much as neither the general council or the village council of the MAC has the authority to settle any fishery or natural water bodies exemplified in the notification dated 7/3/2017 issued by the issued in the name of the governor by the principal secretary to the government of Assam, fishery department, which has been held by this court. It has been fairly held by this court in the judgment and order dated 20/08/24, passed in WPC 3065/2020. Correct? Next para. On perusing the next you're right. The judgment and order dated 20/0/24, passed in WPC 3065/2020 has clearly held that the MAC does not have the authority to settle any fishery or natural water bodies which are within the state of Assam and also within the MAC area. As such, the MAC do not have the authority to make settlement of any fishery with any person. The said power lies only with the Fishery Department, Government of Assam, and the Assam Fishery Development Corporation. In view of the finding by this court that the MAC does not have any authority to settle any fishery or water bodies with any person within the state of Assam and within the MAC area, which also covers fisheries within the MAC area. The impugned settlement of the KD Nala to Sonari Ghat Meen Mahal with the respondent number 5 in terms of the letter dated 29/6/2024 issued by the Principal Secretary MAC is unsustainable. The same is accordingly set aside. The writ petition is accordingly disposed. Without hearing the respondent number 5, let him come in review.
Lordship, the petitioner has been the owner of the vehicle and that the said vehicle was hired.
Item?
9.
Okay, right. Heard, Miss
B. Gogoi, Lordship.
B. Gogoi, for the petitioner, who submits that the petitioner's dues amounting to rupees 21,58,836 has not been paid. Mr.
SR Barwa,
For
all the respondents.
SR Barwa appears for all the respondents. So he is granted 4 weeks time to file affidavit in opposition. This is a matter after 4 weeks.
Notice is.
Acha, issue notice, huh? I didn't say anything.
May it please your lordship. Lordship, the petitioner had entered into an agreement with the Karbi Anglong Autonomous Council, your lordship, following a tender process, your lordship. He was awarded the tender to operate the Karbi Bhavan at Silpukuri for a period of 15 years.
To operate what?
The Karbi Bhavan
Karbi Bhavan.
at Guwahati, your lordship.
Okay, then
So your lordship, there he had to pay annually an amount of rupees 18 lakhs, monthly 1,50,000 approximately. There were some payments made, but there were defaults also, your lordship. But your lordship, the reason for the default is mainly that this petitioner is originally a resident of Silchar, your lordship. His wife has been continually sick, your lordship, and
That
he
is a
has-
different issue. Your wife is sick, your grandfather's father is also not well, or what. Those are all excuses. You see, that is a different issue. There is a contract to run the Karbi Bhavan on, I think, 18 lakhs
per year.
per year. You're not paying it. You're not paying it, so notice was issued to you. What is wrong?
Lordship, thereafter, lordship, from 27 to page number 27 to page number 81 are medical documents, your lordship. But
Maybe,
after that-
maybe those are issues. You see, that is nothing to do with the contract. That is your personal problem. Now, your personal problem, if they want, they'll look into it. You have come to this court
Lord.
only to claim your right.
Lordship,
Now, that's on that they've got nothing.
no, I have prayed before them that I will pay all the dues within 5 months.
That is according to them. We do
They've
not
not
know.
considered it, your lordship.
If
And
they look, if they want, they can consider. It's at their discretion. But you have got no right. You have been defaulting so many years. You have not paid.
lordship,
Only once you,
but as
you
the terms of the agreement kindly say, your lordship, at page number 20, clause 4.
page number 20.
Yes, 2 clauses I'll take your lordship to. Clause 4, your lordship. That's the, may I read, your lord? That the yearly contract money, yearly lease amount, rent, along with the paid vouchers or receipts of the electricity bill must be submitted by the second party to the first party before or within the first week of the succeeding year. And in the event of the delay in paying the contract money or yearly lease amount, rent as stated above, the second party shall pay a simple interest at the rate of 12% per annum for the defaulted period. There is no provision for cancellation of this agreement, your lordship. And the clause number 31, page 23. Page 23, may I read, my lord? In case I don't rectify my default, then the matter has to be either referred to the chairman of the Karbi Anglong Autonomous Council or referred to an arbitrator. But in this case, the matter was not referred to the chairman, but before that, the principal secretary took the decision to cancel, my lord. Page number 85.
Yes, madam, where is the provision for cancellation?
Lordship, our letter is in page
No,
85.
no, in your agreement, madam, in your agreement, where is the provision for cancellation?
Lordship, we have cancelled this on with regard to paragraph 31. Paragraph 31 of the agreement, Lordship, page 23, Lord. Lordship, I may be given time to obtain instruction, Lordship. Lordship may issue notice in the meantime.
No, madam, you see, what happens is, if the dispute still exists, the matter will be referred to the chairman or to mutually agreed arbitrator for that. So you can, let it be referred to the chairman or what?
It
You
was
can pass the same order. Only thing is that it has to be done as per your agreement. So you want instructions?
Yes,
Or what?
I'll
Okay, right. Right, mister?
yes, they, my lord.
Yes?
They.
How come your name is not here?
It's already there, your lordship. It appears in the call.
Okay, heard Mr. S. D. Learned counsel for the petition, who submits that the petitioner was selected to run the Karbi Bhavan at Sil Pukri, Guwahati for 15 years. At a rate of rupees 18,10,001 per annum. In terms of, it pursuant to a tender notice dated,
14/9/2022.
The expression of interest is mentioned, my lord,
dated
9/6/2021.
9/6/2021. Full stop. You have not been paying from 2022, I think.
2022.
Lordship, I have paid
Yeah,
in
paid.
23, I have paid in 24, but erratically, your lordship.
As the petitioner was not paying the rent on time, the petitioner's contract for running the Kabi Bhavan was cancelled by the impugned letter dated
9/5/2024.
9/5/2024.
2022.
Where is that page?
85, my lord.
85.
95, 95/23. Issued by the Principal Secretary, KAC. The petitioner's counsel submits that for cancellation of the contract between the parties in terms of clause 31, the dispute had to be referred to the chairman KAC or to a mutually agreed arbitrator. However, the said clause was not invoked by the respondents and they have instead cancelled the contract agreement unilaterally. Yes,
It is a purely contractual matter, my lord.
but he's saying that you have not, the manner in which the contract agreement has to be cancelled,
My lord.
is by following the clause 31.
My lord.
You have not followed it.
My lord, as they have failed to, my lord, honor the, my lord, agreement, they have not made the payment, my lord,
Correct.
as per, my lord. So
But
the-
where does it say that if they have failed to make the payments, the contract will be cancelled?
but page 85, my lord, annexure 8 is there, my lord.
Page 85.
Page 85, annexure 8. That is the order of the principal secretary, my lord.
No, Mr. Counsel, your contract agreement is there before that.
My lord. Yeah. Last part, as if have breached the terms and conditions of the contract agreement and have failed to comply with the condition of the agreement despite issuance of the letter dated so and so, the matter is referred to and so for resolution of recovery of area rent. So, my lord, there is a clause that if they fail to pay the
Show
rent,
me the clause.
clause 31. Let notice may be issued, my lord, we'll take the instruction for that. But
Please look at the clause.
My
Please look at 81, the 31, clause 31. Which page is that again? 83,
23.
23.
my lord, that is, if the second party commits any breach of the terms and conditions of this agreement, the first party will issue written intimation to rectify such defect. And if dispute still exists, the matter will be referred to the chairman KAC, my lord. So the matter was referred to the chairman of KAC. It appears from the annexure 8, my
Let us
lord.
see, let us see.
So that is a page 85, my lord.
Page 85.
The last line, my lord. Last paragraph. Page 85, annexure 8. As you have breached the terms and conditions of the contract agreement and have failed to comply with the conditions of the agreement despite issuance of letter dated so and so, the matter is referred to the chairman KAC. So it is referred to the chairman KAC, my lord.
Now, where is the KSC decision? Chairman, where is the decision of the KSC?
Chairman, my lord. So
Where
I'll
is
put the
that?
instruction on that, my lord, and I'll place it on record, my lord. The decision of the chairman of KAC, my lord.
But here, by this order only, they cancelled it, my lord.
Where have they cancelled it?
The first paragraph, the part in bold, my
So
lord.
on
Last
receipt of the, my
last
lord,
four
report from the
lines.
chairman, it was cancelled. my
Last
lord.
4 lines of the
Okay.
first paragraph.
And it was
Is it-
cancelled in the May, my lord.
Mr.
Now,
Counsel.
my lord.
You see, this letter, 9-5 is a cancellation of the contract.
My
agreement. But your contract agreement requires you to first have the opinion of the chairman of the KSC. Now, you show me the chairman KSC decision.
My lord,
If it is prior to this date,
My
then
lord.
it's okay.
it should be my lord.
But
should
if
be
if it was prior to this date, then it should have been mentioned here. What was the KSC chairman decision? Out here said that the matter is referred, nothing was referred. Is referred to the, for resolution. So what is
For
the,
recovery rent interest at a permanent other than due liability as per clause 31 agreement to ensure. So it was referred, my lord. So I'll take the instruction on that about.
and where does the KSC say that, the chairman say that the contract agreement should be cancelled?
My lord, my lord.
So,
this
Mr.
Should my lord.
Okay, issue notice. But then if we issue notice, then what will happen? Okay, issue notice, returnable in,
Any date, my lord.
Can I let them take instructions in the, kindly fix it in the next week, otherwise.
it take instruction. Okay. Mr. J. Chutia, learned counsel for the KSCs, submit that he will obtain instructions in the matter, list the matter. Next, Monday,
Third, my lord.
Tuesday.
Tuesday is only third. Pass out to board. Third.
Third will be too much, there's so many, because that is the second last day also.
Most obliged.
Only instruction, no. Not this, we have made some subsequent orders also to this.
Yeah, that they submitted one letter, Lordship.
No, I want the subsequent orders, not this.
Lordship, that is. Even beleg like.
I want the subsequent order because they're out there, their submissions are.
3944 object 2024.
WPC, yes.
39
Meganko,
39
39,
44 44
44.
object 2029 24 sorry
28 of this good.
28/8/23.
so where is the admission?
That is page 13, Lordship. Liability statement is page.
And what is the amount?
Amount is 3,69,135.
3 lakhs?
Balance
69,000, Lordship. 135, page 15.
3 lakhs, 5,699.
yes Lordship 5
It's 5,000.
699.
Oh, sorry,
Balance
Lordship.
amount is
Yeah,
3 lakh
balance is
5,690. And page number 15.
You are registered contractor with who? Morrigan?
Lordship, Moregaon, WR.
So RS to tight. Along board, this will be different. By letter number. This letter is different, huh? Letter number. E dash 542 813 slash RTI slash 2024 slash 6. Dated 28/8/20. Yes, Miss, your name is
DG.
D Jane, correct? And A Gayan will be there for Jashakti.
Yes, sir.
Okay, wait. This is issued by Assistant Chief Engineer. University. Okay,
Item 13 is also similar matter.
same assistant engineer.
Lordship.
Item 13 also will do it similarly, okay.
Only the amount is different.
Facts will be slightly
is
different.
different.
What is the amount?
5,47,647.
5,47,
647.
647. Is this AC is not working or what? Very hot. Very hot. I'm starting to sweat. It's on. This is full. Okay,
Plus,
Item 12.
yes.
Yeah, Lordship. This is matter pertaining to tea promotion and development scheme. So in pursuance of that scheme promulgated by the tea board, we accordingly applied, and the tea board has also sanctioned a pre-approved sanctioning was there. And accordingly, after the permission NOC, we uprooted the
Now tell me this T board, this scheme, what is the validity period?
validity period is itself in the scheme, my lord.
This
It is 1718 to 1920.
to 20.
Yes, yes.
Now you have applied for this subsidy
Yes,
for which period?
We have applied accordingly in the initial period of 17. The matter was approved by the T board. Then we started our uprooting. They inspected. They inspected.
No,
the
so
site.
this scheme ended in 2020, correct?
Yes, and the first installment we are entitled, and also the second installment. For that, at this stage, my lord, the notice may be issued.
But why you come so late?
No, we are immediately, because after the uprooting, then we have to wait for 2 years. Because second installment, I am entitled after 24 months, as per the scheme, my lord.
Okay, right. Heard Mr. P. Data, Senior Counsel, assisted by Mr.
Yes, second.
S. Data. For the petitioners. For the petitioner, who submits that the T board has not sanctioned and released the first and second installment of the subsidy under the Tea Development and Promotion Scheme amounting to rupees 33,25,143.10. Issue notice returnable in 5 weeks. Mr. M.R. Adhikari, except notice on behalf, they have all responding. This is the matter after 5 weeks to enable the respondents to obtain instructions and file affidavit if necessary.
Technical, item 15.
No one appears on behalf of the petitioner. List the matter when? After vacation. Give a date after your date. Give a date. Huh? No, no reception.
Item 16.
My colleague was appearing in the matter. He's in some difficulty today, but the instruction we have received. Lordship may kindly like to have a look.
No, just show him to him.
Yes.
Let him see it. It's in regard to the serial number 6 and 11. Whether there is any final determination made.
Yes, your Lordship, as per our calculations, only
Are you to receive or are you to give?
we have to pay to only one, your Lordship, that is serial number. Petitioner number 8, your Lordship.
8?
Yes,
How come?
Ramjan Ali.
Para 10 of your affidavit, let us see. There are 10 of your affidavits. At page 6.
Yes. Yes.
Actually, with regard to 6 and 11. It's only, so it's, that is with regard to whom?
That is with regard to all of them, your lordship, all 14 of them.
Yes, but yeah, so according to you,
Only
payment has to be made to,
respond number 8.
what about 6? No, nothing. So only to 8.
Only to 8.
How
we have-
much?
To 8, we have to pay 1 lakh. No, it's 1,96,000.
96,
96,036
36?
rupees.
And for the rest?
Rest, in fact, we have to receive from them.
Lordship, from their affidavit in opposition, petitioner number 1 is to be received from them 627, Lordship. Petitioner number 5, petition number 7, Ramdan Ali, here it,
Where? As per their affidavit,
Lordship,
yeah,
Lordship.
what? Only for, as per their affidavit, petitioner number 1 is to receive 627.
Lordship,
Then
Then-
petitioner number 7 has to receive 1,96,000.
Lordship.
Yeah,
Then
8, I mean, petitioner number 8.
Petition number 10, 1,95,000.
1,95,000. What about petitioner? Yes, what about this, page 6 of your affidavit?
Yes, your lordship.
This is the chart you have given.
Lordship, this chart, there have been some more payments, your lordship, after that, your lordship.
Okay.
After that, lordship, I'll just, lordship, I can like to have it. I'll.
Yes,
The chart at page number, the second page, your lordship,
yes.
it has these net payments and receivables from all the parties serially.
Okay, so you have minus it. Okay,
Yes.
okay. Okay. Yes,
Lordship, Lordship may kindly take affidavit in opposition filed by
Yes,
the
I've got it,
Lordship. The statement given there in instruction and here, there are contradiction is available there.
no, they are saying that subsequent to this, some payments are now receivable by them.
Yes, sir. We have subtracted it from.
Now, can you put this in the form of affidavit?
Very well.
I think better, otherwise to.
Yes, sir. Moreover,
Mr. KP Pathak. Learn counsel for the APDCL submits that further instructions have been received. And in terms of the further instructions, the APDCL is to pay rupees 1,96,036 to the petition number 8 only. There is no liability payable to any other petition. He submits that he will submit the additional instructions by way of an affidavit within 2 weeks. List the matter of appeal.
Can I take back the instruction?
Yes, you submit it and then we finish, close it up, that's all. What to do, madam?
This matter, today we have filed our affidavit.
You're filing affidavits. Oh, very good. Ms. D. Jain submits that the Water Resource Department, correct?
Yes.
Will be filing their affidavit during the course of the day. Accordingly, this matter, when?
Your Lordship, next.
List the matter in next week. Yes, there is some anomaly.
My lord, but after verifying the record, my lord, that admitted amount is, my lord, 1,25,152, my lord. I have received the instruction, my lord, but I could not file the affidavit.
Yeah, you have received it. Have you filed, are you filing any affidavit?
My lord, I'll file.
Okay, Miss Yudas. Submits, that no one appears for the petition on court. Miss Yudas prays for a week's time to file additional affidavit showing that the admitted amount payable to the petitioner is only rupees 1,25,152.
Lordship,
List the matter in the next week.
obliged.
Yes,
Well, I see matter relating to transport subsidy.
you are filing affidavit or not?
Also, in fact, there are two judgments of this honorable court itself.
Huh?
There are
Yeah.
two judgments of this honorable court on the same issue.
Okay. It's a covered matter.
In fact, my lord, what is the happening, my lord? The transport subsidy scheme doesn't provide for filing of any time period for filing of the claims. Now, there was circular in 1994. This says that it may be 1 year from the date of incurring of the expenditure. Now, that remained as it is. And after 2 decades, my lord, the government again, my lord, said that despite of the circular, the claims are being admitted even after 1 year. And it should be strictly enforced. Now, that was their internal communication. Now, in similar circumstances, my lord, our claim was about 3-4 months later, my lord, filed later on. And that was rejected on the ground that it was beyond 1 year. Now, similar issue came up before this honorable court, my lord. And you lost not an issue, my lord. One second, sir. I'll take a receipt to para 18, my lord. May I read, my lord? The transport subsidy scheme is a part of the government initiative to encourage industrialization in what are called lesser development regions of the country and thereby accelerate economic development of the such states. Objective of such scheme being beneficial, reasonable, and liberal approach should be required to be taken while implementing such scheme. Of course, the implementing agencies have to be alert to ensure that bogus or stale claims are not entertained. This court understands that the time limit of 1 year prescribed by the authorities for grant of transport subsidy is for administrative convenience and to eliminate belated claims or claims which are not genuine. This time limit is 1 year as prescribed is not an inflexible rule and is capable of suitable relaxation in appropriate situations. Now, this was again followed. Paragraph 25, my lord, by following the earlier judgment. The object behind framing of the social scheme is primarily beneficial. It was for providing incentives to the interested entrepreneurs, industries, etc., to set up industry units in the industry less developed region like that of the northeastern region. A legitimate claim made by an industrial unit for transport subsidy in the subsidy scheme is to be rejected only on merits and is not to be rejected on the ground like the ones assigned by the respondent authorities in the case in hand. The court is of considered opinion that a genuine claim of the applicant of a transport subsidy and the transport subsidy should not be rejected for a reason which is not attributed to the applicant, as the transport subsidy scheme was framed for the purpose of giving incentive for setting up an industry unit in the lesser developed region, the northeast region, the respondent authority are duty bound to adopt a reasonable and liberal approach in processing the claim of such an applicant. In such view of the matter, the court of the view, the claims of the prosperity for the under so-and-so scheme in the aforesaid 5 parties which are deserve consideration at the respondent authorities. Now here the claim was rejected only on the ground that it was beyond 1 year.
When did you submit your claim?
My lord.
When did you submit your
Well,
claim?
it is there, Your Lordship, fine. You'll also find it page 51. Lordship, fine. For the period from 1/7/2015 to 39/2015, it was submitted on 9/11/2016. As you also got it, my lord.
Where does it say 1 year? Where is that 1 year?
My lord. The first circular. You'll also find. At page 52. $52 million.
Yes.
You'll also find. It says, my lord, I'm directed to refer to suppress so-and-so of the ministry letter dated so-and-so. Copy enclosed wherein it was laid down that under no circumstances investment claims of more than 2 years will be entertained.
This is 2 years.
No, my lord, Your Lordship.
Yours is 1 year.
My lord, Your Lordship. It is
Huh?
it is modified to, it is modified to page 53.
Oh,
Your Lordship.
The last paragraph.
Last paragraph, my lord. The state government authority should advise the entrepreneurs to submit subsidy claim quarterly. Henceforth, under the circumstances, they should accept claims more than 1 year old from the date of occurring of the expenditure. They should not.
They should accept.
They should not, my lord. In the original copy is here, my lord.
They should not. It should be, they should not.
My lord. Thereafter, you also see another notification. Of the year 1994, my lord. First of 1993, it is acts on your lordship, and 1994 at page 56.
Yes.
I am directed to refer to para 2 of this ministry letter event that is so-and-so, copy in English for ready reference, where inter alia it is held that down that under no circumstances, the state government unity should accept claims more than 1 year from the date of expenditure. It is once again repeated that this condition should be strictly enforced by all the state governments and union territories. This was in 1994, my lord. Thereafter, it's Lordship, page 57. After 20 years, it says, my lord, the undersigned is directed to invite reference to the department's earlier letter dated so-and-so, wherein the state government entity have been instructed to advise the entrepreneurs to submit claims quarterly basis. And under no circumstances claims more than 1 year from the date of incurring expenditure should be so and so. It has come to the notice that Department of the State Government has accepted claims more than 1 year or from the date of incurring of the expenditure. It is clarified that the expenditure is deemed to have been incurred on the date on which the raw materials is received at the state unit of finished product is dispatched from the unit. In view of this, the claim of the particular quarter will become fully admissible if the period of 1 year is counted from the beginning of the quarter and not from the end of the quarter. In case period of 1 year is counted from the date when the quarter or from the end of the quarter, the claim may be admissible partially or less than so and so. Now we'll also
At the
kindly see,
beginning of the quarter.
my lord. Now we'll also see kindly, look, from 1993 to 2013, the ministry is saying that in spite of the circular, the claims were entertained. Now, if it would have been mandatory, then from 1993, the question of admission of the claim does not arise. And even if it has been admitted, the amount cannot be disbursed. So that's why, my lord, this honorable court also held, my lord, that it is for administrative expediency and not a time limit, because no time limit were prescribed under the scheme 1971. And thereby, the court directed that stale claims may not be entertained. Now, in my case, you'll also see the delay. What is the delay? It cannot be said to be a stale claim. And in view of this honorable court two judgments, my lord, my claims which have been submitted after 3 or 4 months. My lord, that-
So these judgments have not been challenged.
no,
Yes.
So far as Lordship, judgments cited by my senior friend or concerned, Lordship, I've got nothing quarrel on that. Lordship will just come to paragraph 18 of the first judgment cited by my senior. That is 2013 1 GLR 359.
Yes.
It is not a matter of course that it can be relaxed. Lordship will come to the last sentence of paragraph 18. This time limit of 1 year as prescribed is not an inflexible rule and is capable of suitable relaxation in appropriate situations. Now, as of, it is not a matter of right that it has to be relaxed. Now, if everything that we have submitted is okay, then perhaps. Otherwise, it's not something as a matter of course that it can be relaxed. That is my answer.
So who should decide that?
No, Lordship, he has submitted his claim. The authority has to see whether everything is in order or not. Now, for him to make corrections now, if there are any, that would be I would say, a stale claim. If everything is okay, yes.
Yes.
and also see it has already been recommended, page 8, my lord, page 48. The claim after verification was forwarded. And it has not been rejected on the ground, my lord, that the claim was not.
So let them decide afresh.
Yes, my
Let them
lord,
consider afresh.
if the claim is genuine,
If your Lordship sees this document at page 48, it is forwarding the documents.
yes, if the claim, my lord, you'll also see what is said, my lord. The judgment, just my read, my lord. To eliminate belated claims or claims which are not genuine.
Where are you reading?
Para 18, my lord,
Page
page of the judgment, my lord.
of judgment.
First judgment.
Yes.
My lord, you'll also kindly see. This court understands that the time limit of 1 year prescribed by the authority for grant of transport subsidy is for administrative convenience and to eliminate belated claims or claims which are not genuine. If they are not genuine,
Lordship, let the authority have.
yes, they will decide. If it is not genuine, they will reject it.
Yes, yes.
You're right.
But not the, on the ground of, not the, that it is related.
The belated I have already submitted, Lordship. It is
Dr.
not-
A. Saraf, Dr. A. Saraf, Learned Senior Counsel for the petitioner, assisted by Mr. Huh? N.H. Datta. Also heard Mr.
I am for 1 and 5 and 6.
1, 5, and 6.
Yes, Lordship.
Who else? Your name?
And Kalita.
N. Kalita. Appeal for respondent number? 2, 3. The petitioner's case is that the petitioner's the petitioner's claims for transport subsidy for the period 1/7/2015 to 31/9/2015 and 1/10/2015 to 31/3/2015 have been rejected by the respondents. By which respondents?
By the, it has been communicated by the District Industry and Commerce Center, my lord.
By the respondent numbers?
My lord, page 51. Respondent number. Real number is it?
By the respondent number 4. On the ground that the same was time barred. The petitioner's counsel submits that the time period of 1 year prescribed by the authorities for making applications for grant of transport subsidy is not an inflexible rule, and the same is capable of suitable relaxation if the claims are genuine, as held by this court in the case of Ishwar Food Products Private Limited versus Union of India and others, 2013, 1 GLR 359, and in the judgment and order dated 29/8/23, passed in WPC 329/2014. The petitioner's counsel submits that as the present case is a covered case in terms of the 2 judgments cited above. A direction should be issued to the respondent number. To which respondents? To all the respondents or what?
It has first to be considered by the state. Then the
Commissioner, my lord, it will be commissioner. my lord. This will be to the respondent number 3.
To the respondent number 3. To reconsider the case of the petitioner in terms of the judgments passed by this court, as the claims of the petitioner are genuine. Person. Next, Mr. R.K.G. Chaudhary, the learned assistant SDI, and deputy SDI, and Mr.
N. Kalita on
And-
behalf of A. Kalita.
and N. Kalita on behalf of Mr. A. Kalita, counsel for the Commerce and Industry Department. Submit that the time limit prescribed by the state respondent for making applications for grant of subsidy under the Transport Subsidy Scheme, 1971 is 1 day. No, is one year, and in terms of the orders passed by this court. Suitable relaxation can be made only in appropriate cases, which would have to be done by the respondent authority. Yes, sir. I have heard the learned counsel for the party. The judgments cited by the petitioner's counsel shows that the time limit of 1 year for submission of the claim for transport subsidy under the Transport Subsidy Scheme 1971 cannot be an inflexible route, and that the same can be capable of suitable relaxation in appropriate situations where the claims are genuine. Para 18 of the judgment of this court in Para 18 judgment in this court in Ishwar Food Products Private Limited Supra and Para 25 of the judgment and order passed in WPC 329/2014 Emami Limited versus Union of India and others is reproduced here in below as follows.
Below the directions you will also kindly see in the Imami's case, below. The last 5 lines below. According to the petition disposed of directing the respondent authority more particularly so and so to process the claim of the petition strictly in merits in terms of the provisions contained in the Transport Subsidy Scheme 1971 in an expeditious manner. In processing the claims, the amount claimed respect of so and so are found entitled the petitioner company. The matters will be decided and thereafter necessary steps for disbursement of this will be undertaken in consultation with the department of so and so, considering the preceding work so and so within 4 months. Paragraph 25, last 5-6 lines. In such view of the matter, this court of the view that the claim of the petitioner of the subsidy for the aforesaid periods deserves reconsideration at the respondent authorities. Accordingly, the petition disposed of. Sorry.
Next paragraph. In view of the decisions of this court quoted above, which has attained finality as on date. The respondent authorities are directed to consider the case of the petitioner for relaxation of the 1 year period required for submission of the claims for grant of transport subsidy in terms of the Transport Subsidy Scheme, 1971. And NAFUSA. Thereafter, if the respondent authorities come to a finding that the petitioner's claim is genuine, and the genuine, which requires relaxation of the 1 year time limit, the respondent authority shall take necessary steps for grant of the transport subsidy as per his entitlement. So, sir, the entire process should be concluded within a period of 4 months from the date of receipt of a certified copy of this order by the respondent number 3. The writ petition is accordingly disposed.
Now, with due respect, Lord, after the finding of this honorable court, the court has not said that for reconsideration of the delay, the court has said, Lord, if we consider it on merits, Lord, some kindly see because
No, with this one out here, it has said that,
the Lord, some kindly see, Lord,
the claim or something, there was no delay in the verification of claim, there was no delay about. Okay. Yours is how many delay? How many? 1 year, more than a year?
not more than a year, Lord. Around 10, 11 months.
10, 11 months. Okay, don't say whatever I said. Just read that last part. So what is wrong with this point?
No, Lord, what I was saying, Lord, that since the honorable court has said, Lord, that this is one period not flexible and directed the case to be examined on merits. The court said that, Lord, if the claim is not a stale claim or, Lord, is not genuine, then it can be rejected. Because relaxation again, Lord, the second round will start, Lord.
Only problem is, if they don't decide that, what will happen supposing in a claim set after 3 years or 4 years?
Lord, this case, that's why I'm saying, Lord, in this case, the dates have been given. Then what is the delay? Stale claims means somebody comes up after 5 years, 6 years. That is why the court said that in a case of stale claims or claims which are not genuine, that can be rejected. But Lord, again, what will happen, Lord, the one line order will come that no, cannot consider again, Lord, the same after so many years, the issue will arise. If the claim is ungenuine, then they will examine on merits.
Yes, sir. Out here, how much of delay was there in this Imami case?
More than 1 year, Lord.
More than 1 year
Yeah, it's around 1 year, 9 months.
delay in that. Okay. Whatever I said, just read the last question again, the last paragraph. Anyway, I'll make the correction later on, huh? You do it, give me, I'll do the correction.
I'm obliged. Lord.
Yes, what to do?
Also, I need some time, Lordship. This matter has been listed, Lordship, for the first time, Lordship, after 2018, Lordship. Okay.
Okay, mister?
Can you stop now, Lord? And Lordship, as per my instruction, he is no more, he is expired, Lordship. They have no idea, they have no contact with the petitioner.
Miss
Ebora.
A. Boralan, counsel for the petitioner, shall obtain instructions as to whether the petitioner is still alive and whether they are still pressing their claim regarding payment of contractual dues. So on the other hand, Mr. N. Upadhyay, Learned Counsel for the Irrigation Department, shall file affidavit,
Or instruction, Lord.
shall obtain instructions
2 weeks, Lord.
and slash or file affidavit. List the matter on, give a date.
23rd October. Okay. 28. Lordship, similar pair in this case also, Lordship, right?
Okay.
Similar matter. 21.
Yeah. Obliged, Lordship.
Lordship, the date is same.
Same.
Obliged.
Yes, legal. My lord, here in this case, my lord, paragraph 4, my lord. According to petitioner, my lord, while he was working as president of the my lord Panchayat, he,
Mr. Council, what is the term of a Gan Panchayat?
my lord, there is a, my lord, it is called, my lord, retire, my lord Panchayat.
No, what is the term of a Panchayat? What is the term? 1 year, 2 years, 3 years,
5
4
years.
years? Oh, 5 years? Are you
Like
sure?
term is last year over, my lord.
Huh?
This term is last year over.
Then will become infructuous. There's nothing here.
Only lordship,
It's a scheme.
Yes.
Scheme, Teddy, you want those schemes to not to be implemented. huh?
only my lord, lordship, I may be allowed to approach, my lord, before the concerned authority.
That is, okay, you
Yeah.
withdraw this with liberty.
Fine.
Withdraw this. Mr. M. Babuya, learn counsel for the petitioner,
Yes,
praise,
term is over, my lord.
praise that as the term of the Gan Panchayat is over, he may be allowed to withdraw the writ petition with liberty to approach the appropriate authority.
Fine.
The prayer of Mr. M. Babuya is allowed, writ petition dismissed as withdrawn,
Well, kindly,
with liberty and faithful.
kindly close, my lord.
Okay, closed, closed.
Keep your mind.
25.
This is a case with regard to non-payment of contractual.
Yes,
Lordship, this matter has come after some time. Lordship, may give us some time to obtain updated.
correct,
instructions.
okay. Okay, right, Mr.
M. Bhuyan, Lordship.
M. Buya appearing on behalf of Mr. B. Gogoi for the PWD is granted 3 weeks time to obtain instructions.
They have not filed any affidavit. It may be filed.
You see, Mr. Council, it has come after 3 years,
31-3.
3.5 years in fact.
They have taken time on the earlier occasions also.
Mr. Council, it has been
It
listed
is an
only
admitted
twice.
position.
In the 6 year, in the 4 years it has been in this court, has been listed twice. You are also not pressing for it to be listed. You never prayed any time. Then
Because it is an admitted amount by them also. It is there.
maybe, but then you're not no hurry to get the money. So why you suddenly is risen, woken up after 4 years saying that as if the sky will fall or something like that. What is the matter with you, sir?
Obliged.
26.
Lordship, Mr. Esbora has some instruction. So let the matter be taken after some time. He's on leads.
Obliged.
27.
Yeah, please, your lordship, my senior is on
Your
leads. Please
lordship.
pass over the time.
Non-payment of supplies based already respondent number 2 is filed an.
He is admitted the
Yes,
amount.
admitted amount, lordship. Kindly
And
propose a
for
percentage.
respondent number 1, I want to file affidavit, lordship.
Why?
Lordship, actually, SAW department has requested us to supply the seat, lordship. Accordingly, we have supplied the seat to the petitioner, but when we file
By the seats to the petitioner?
is.
Huh?
Lordship,
It is the agriculture department's matters.
departments are involved, lordship.
Okay.
That's
There is
why
the
our
already-
response is required, lordship. As per
Already
high
parties
one-
there.
Huh?
Parties already made, lordship.
But when did you file, madam?
Kindly
So
one week
time is
maybe
already
given, lordship,
taken
I'll file
several
affidavit.
times, lordship. So this is the admitted amount and respondent number 2 is also stated that it is the admitted, but the fund was not sanctioned. So from
Some inquiry is going
2019
on
onwards.
Just a minute, madam,
lordship,
just a minute. Let me try to get to the bottom of this. First of all, who are you? You are respondent number?
One, lordship.
Government of Assam.
Agriculture department, lordship.
So what have you got to say?
Lordship, actually, SAW department has requested us to give some seats to some beneficiaries, lordship. Then we collected the seats from the petitioner, and when we required the money from the SAW department, they they said that as per our verbal instruction, Lordship, they have not provide the money to us, Lordship. When we,
Madam, this is between you, you see, the char areas department
Lordship,
and agriculture, you are a part of the government. Whatever problems you have, you find it out in your departmental meeting.
Your Lordship, some inquiry is going on, so let my ma'am senior can take up this matter. Lordship, affidavit is filed as
Just a minute, madam, just a minute.
Kindly dispose of this matter.
Let us wait for your senior. Let us wait for it.
It is a non-payment of contractual dues. We already coming, we're still awaiting instruction. Lordship.
No.
Still awaiting.
No one appears for the petitioner on call. Oh. Yes, so what to do?
Actually, last chance when we granted is that if instruction not forthcoming, that can dispose of.
Mr. R.R. Roy, counsel for the PhD department. He granted a further 3 weeks time to file affidavit. This is the matter of appeal. What do you want?
43 is the same, my lordship.
43. 43 on the fifth. 29.
Oh, like.
yeah, my lord, we have filed the affidavit, my lord. We have admitted
Item?
the amount.
29.
We have admitted the amount, my lord, 37,06,668, my lord, instead of 43,05,882, my lord.
You have admitted to the amount of 3,76,000. Correct.
Yes, 3,76,000
So we'll dispose it off in that line. What do you mean?
in that amount.
Because he has made double billing according to him.
Double billing for two.
Correct. Heard, Mr. Huh?
Elmo.
L. Mohan, counsel for the petitioner. As well as Ms. Yu Das for all the respondents. The grievance of the petitioner is that he is the registered owner of vehicle bearing registration number AS-16-AC-1184 bracket winger, which was hired by the respondents between 2020 to 2021. However, the outstanding bill of the petitioner amounting to rupees 4,35,882 has not been paid to the petitioner. Next part, Ms. Udas, appearing for all the respondents, submits that the admitted amount payable to the petitioner is rupees 3,76,688, as against the claim of rupees 4,35,882 made by the petitioner. Ms. Udas submits that the petitioner's claimed amount is not correct, as the petitioner has wrongly made a claim for bill number, where is that? Bill number, bill for bill number 14 twice, is it?
Yes, ma'am.
Bill number 14 twice. Which is reflected in Annexure A to the affidavit in opposition filed by the respondent number 3. I have heard the counts for the parties. The petitioner has made a claim for rupees the petitioner has paid for payment of hiring charges amounting to rupees 4,35,882. However, on perusing the affidavit filed by the respondent number 3, it is seen that the petitioner had made a claim of rupees 56,925. That is not here.
Look, he claimed that double bill, my lord. This amount has been claimed, my lord, double, twice, my lord.
Where?
Page, my lord, bill number 14, my lord.
We had affidavit.
Okay, anyway, what have I said? However, as the respondents have taken a stand that the petitioner has made a double claim for rupees 56,925, this court would have to. This court can only allow the admitted claim. Full stop. The amount that is not admitted by the respondents, no, the petitioner would have to approach alternative forums for the amount that has not been admitted by the respondent, as the same would require recording of evidence. Full stop. As the respondents have admitted that they are liable to pay rupees 3,76,688 to the petitioner as hiring charges for his vehicle, the respondents are directed to pay the same within a period of
3 months, my lord.
3 months from the date of receipt of a certified copy of this order. The writ petition is accordingly disposed of.
They are supposed to give instructions, my lord.
Lordship, I have received the instructions, but.
You have received?
Hmm.
You have received the instructions?
Yes, Lordship.
To what effect?
Lordship, the petitioner, remaining amount, balance amount was 54,94,071 rupees. Out of that, Lordship, 16 lakhs something has been is deducted for, forest royalty. But
16,
16 lakhs 55,000.
forest royalty.
But the remaining 38 lakhs, I have no instruction, Lordship. That part I have to take.
Then you pay.
Lordship, let me take instruction regarding that 38 lakhs.
On security deposit.
Yes, ma'am.
Okay, right. The petitioner's case is that the balance security deposit amount of rupees 54,94,071 has not been returned to the petitioner despite the petitioner having completed the work contract. Next paragraph. Mr.
C. Sharma, Lordship.
C. Sharma appearing for
4 and 6.
4 and 6 submits that as per instructions received by him. Rupees 16,55,000 has been deducted from the balance security amount of rupees 54,94,071 on account of forest royalty. He however submits that he has not received any instructions with regard to the remaining 38,39,071. He is accordingly granted.
4 weeks time.
Why?
At least 3 weeks, Lordship.
Why?
We'll like to file our affidavit also, Lordship.
What affidavit? It is only a question of money. Otherwise we'll tell them to come here. What do you mean? If they're liable, they've got to pay. Whether you owe him 1 rupee or 2 rupees, just say that. Why is the affidavit necessary? I don't know.
Then Lordship may grant me 3 weeks time, Lordship.
Why 3 weeks? You cannot try to take his money and keep it with you in your
Page 104, your lordship. Was 48.2. No contractor will come up.
Huh?
This situation, no contractor can do work. Page 48, 104, 48.2. On completion of the whole of the works, half the total amount retained is repaid to the contractor and the half when the defects liability period has passed.
Has the defect liability
Yes,
been
yes,
cleared? That's over?
they have given the
Okay, right,
completion
next.
certificate also,
As the defect liability period
165
is
days.
is allegedly over, the respondents council shall obtain instructions by Monday as to why the balance amount has not been, balance security deposit amount has not been paid to the petitioner. In the event the respondents council is unable to obtain instructions, the concerned head of department may be asked to appear in the.
And all the,
We will call them, we'll call them. This is not done.
all the
Next
from the
Monday.
security deposit, they want to deduct royalty amount has already been paid.
That is, there's an excuse. That's what they did excuse. You listen this Friday. This Friday, this Friday. If they don't do it this Friday, then we'll make sure that they come on Monday.
Like,
Supplementary admission 42. Item? Yes.
So in this matter also I need some time also.
How much is the amount claimed?
31 lakhs, 62,080. 83.
Also in this matter, the last scheme, that is SDRF scheme. So Deputy Commissioner. Scheme number 3, Lordship, in the.
You see, there is a document which he has furnished.
Yes, Lordship. The amount is okay, Lordship, but the scheme number 3, that is an SDRF scheme, Lordship.
So,
So that scheme, Lordship. That scheme will be, DC will be the appropriate person to pay, Lordship.
is DC a party here?
No, Lordship.
Make him a party. Make DC a party. You file an affidavit anyway.
Yes, Lordship.
1 year, there you go. This has been listed earlier,
Yes, sir.
December last year. Now it's already September, going to be October. Right, Mr. C. Sharma, Land Council for the Water Resource Department, is given 3 weeks time to file affidavit of opposition. This is the matter on, give a date.
Online.
Time being item 27.
Wait, please, your lordship. My lord, I'm praying this matter may be listed immediately after vacation.
Why?
But inquiry is going on, my lord. Because then director of WMD has issued the work order without any financial sanction from the finance department or without any approval from the WMD department. So lordship may kindly fix the matter immediately after vacation. Inquiry is going on, everything will be clear, my lord. Lordship,
You have received parawise comments, that's what you said on the last day.
yes, I filed affidavit also from the director, because director is the only respondent here. WMD is not a party. After the lordship, one meeting was held. I was also present in this meeting. It was on 12. This is the meeting, my lord. The work order issued by the director himself.
But then you have used the products.
Lordship,
Yes,
that's why
supplied.
they are verifying all. They are not saying that we are not paying them, but sometime lordship only, immediately after vacation, my lord. The minutes, the last paragraph, my lord.
But everything should be ready by next week, by next time.
Lord-
Otherwise,
My lord.
Miss MD Bora, learned counsel for the, no, Miss
Yes, Chakravarti.
S. Chakrabarti, learned counsel for the petitioner submits that the contractual dues payable to the petitioner amounting to rupees 1,15,96,095 has been admitted in the affidavit, in para 6 of the affidavit filed by the respondent number 2, that is the director of
Shore areas.
Star
Development.
Areas Development Department,
Development, lordship.
Star Areas Development. Pusta. Miss MD Bora, the learned counsel for the respondent number 2 submits that an inquiry is underway to ascertain whether the director of, whether the respondent number 2 had taken the approval of the finance department and other nodal departments for supply of the materials for which the present case has been filed.
No.
She submits that in terms of the meeting minutes dated 12/9/2024, held under the chairmanship of the Minister, Welfare of Minorities and Development Department. The inquiry would be completed within period of 15 days.
My lord.
Accordingly, let this matter reviewed it.
The matter, lordship. 30th of.
Deeply obliged, lordship. Lordship may give this minus the part of the record.
Yeah.
Deeply obliged.
32 for orders.
Lordship, service on respondent number 5 is completed as per Algebra Code Order 21-8.
Where does it say it's complete?
Orange color.
Where is it complete?
It's flag mark.
Huh?
It's that orange color flag.
Orange color.
21-8.
Huh?
21-8. Algebra Code Order.
21/8?
2020.
Is this 2013 matter?
Yes.
Are you still in contact with your client?
Yes.
Huh?
Yes. I'm photographer. But the thing is,
Who's coming for the other side?
that's a-
I know. Right, petitioner's counsel is present. Who is the private party?
Private party is not one labor union.
Respondent number?
Respond number 5 and 4. Both are private party.
No one appears for the respondent number 4 in fact. What to do? This is the matter after the vacation.
It was part of the impact, but.
33.
Lordship, this is a review petition filed by the state, Lordship. Review of the order at page 18, Lordship.
Page 18. Okay, so the thing is,
The others have filed their Wakalatnama, Lordship.
no, no, but they have not come.
Today they are not appearing.
No, they filed Vakalnama. No Vakalatnama was
In
filed.
the month of August, they have filed, Lordship. That's it.
Of August?
Yes,
August which year?
this year, Lord. 12th of August.
No,
RBI.
No, because this last, it was the review petition of 13 March. No other date.
Check for
No, the problem is RP Hazarika, okay, he filed it. No.
Yes.
28th February, he filed it. It is there. Okay, right. Anyway, we'll allow it, no point. And what to do? If they're not coming,
Lordship may give him one more opportunity on next day, Lordship will decide.
is he around? Is he around here?
Yes, sir. Friday I make him, Lord.
There's some, no mobile number.
RBI.
No, you see, because in February, he said that he will file Vakalatnama.
Yes, Lordship.
Then in March, he said that. Okay, and he has filed Vakalatnama. But okay, right. Mr. P. Nayak appears for the review petition. No one appears for the respondent, even though Mr. R.P. Hazarika has filed Vakalatnama on behalf of the respondent. What to do? What to do? Huh? In the interest of justice, leave the matter on Thursday.
Lordship.
You please tell him.
Lordship.
Because this, we can dispose it of this.
Lordship. I think 34 to 27. 26.
It is a review petition. Lordship,
Where are they? Where are these councils?
Lordship notice has not been properly served. In item number 34, Lordship notices used to be issued in 3 items. We took steps, but nobody appeared. Your Lordship, the question was, Lordship, on last occasion, whether Ashish Agarwal is applicable in this case. But in this case, notice was issued on 31/3/2021.
31?
31/3/21.
21.
Yes, sir.
This review petition of 24.
Yes, no, Lordship. What happened is that this petition.
That okay.
And Lordship,
31/3/21.
yes, sir.
Okay, so 1 day prior to that.
Prior to the,
1 day prior to the amendment.
by mistakenly, Lordship, I also agreed to the submission of the land petition. In 3 cases, Lordship is pleased to issue notice. Item 34 notice may be issued, and Lordship may hear the matter. And Lordship, paragraph, I have given the judgment of Ashish Agarwal, Lordship, paragraph 11 is clear.
34 where we should notice? No.
No, Lordship, notice has been. In
35, 36, 37 where we should notice.
Lordship,
Okay, right, in 34, you're right. Heard Mr. S.C. Khair, learned counsel for who submits that in view of the wrong concession given by the review petitioner's counsel at the time of disposal of the writ petition, a wrong order has been passed by this court. He submits that in terms of the judgment of the Supreme Court in Union of India versus Ashish Agarwal, reported in 2023, 1 SCC 617, comma. The notices that were issued under section 148
Yes.
of the Income Tax Act prior to amendment of section
148A.
one prior to amendment of sections 147 to 152.
Yes.
And insertion of 148A. Comma, the judgment, the above judgment of Ashish Agarwal could not have been applied to the facts of this case. Correct?
Yes.
Issue notice returnable in 3 weeks. 3 weeks, review petitioner takes steps for service of notice upon the respondent by registered post with any within
2 days.
within 2 days. But about Dusty, no need.
No, see, difficult.
Difficult. And leave the matter after 4 weeks.
Not even item 35 to 37, service may be awaited.
Let us see 35 to 37. You see, they're not coming, I think. I think we'll have to dispose of the review. Then only they'll come. It says notice in respect of respondent number 1, wide memo so has been issued and the same is transmitted by registered post. They're not saying whether they have received it or not.
Will be awaited, or I will take first steps in all the cases.
It says a copy of the said notice may be seen at flag X. Let us see. Flag X. Where is flag X? Let us see here. Copy of the postal journal, copy of postal track consignment report. There's no X.
Let's see, I will take first steps in all the cases.
Okay, right. I heard Mr. F.C. Keller counsel for the petition, review petition. No one appears for the respondents. Petitioner shall take fresh steps for service of notice upon the sole respondent by registered post within 2 days. List the matter. Give a date after application. All the matter. Yes.
The review of the order dated my lord 7/6/2024, my lord. By my lord placing the record, my lord.
Review of the order dated
7/6/2024, my lord. PS 91. By my lord placing.
section, yeah, yes, all of them same date, all of them same date. Yes,
This one.
item, yes,
13.
yes, where is the order? This is a review.
Review,
Yes,
my lord.
my God, all reviews.
PS 91, my lord. Operative portion is my lord is,
Page 91.
yes, my lord. Operative portion last, my lord, is my lord. 96, my lord. Because my lord, we have placed the, my lord, letter dated 4/4/2023, my lord, as a show cause notice, my lord. Instead of my lord, original show cause notice, my lord, that is also in the record, my lord. Due to the inadvertent, my lord, we have, my lord, wrongly, my lord, placed that record, my lord.
Lordship, though we have received a copy and accordingly we have informed the client.
But till now, we have not received any official engagement in this matter in the review petition. We have not received the Wagala number to that regard.
No, anyway, the facts are clear.
Lordship may issue
We'll,
this at this
huh?
stage.
No, there's nothing to issue. The thing is this, you see, the
Because we are not
order,
authorized to represent the.
we will restore the writ petition, that's all.
Yeah.
We'll just allow the review. Because the review order had been passed on the basis of the letter dated 4/4/2023, which was shown to be the show cause notice. Actually, it was not the show cause notice. So it was a mistake committed by the review petitioner. So mistake, we'll allow that. That's all.
Well, if that's the case, if the report was written from that point of time, they would have produced it that time.
No, it is there.
Oh,
It is there in the writ petition. Show me the writ petition. Which page? In the writ petition? Was it here? Is it here? Is it in the writ petition?
So cause notice,
Yes, the show cause notice.
not man.
Have you brought the show cause notice?
Yes, my lord, the record is there, my lord.
Show me.
It was never placed in the repetition.
Show me.
If the document was.
Mr. Sharma, you are there.
Why couldn't they?
I
produce
agree
it?
with it.
Ah.
As of now, since we do not have Wakalatnama in this matter, so I was not appearing. But
Has-
the
has
issue is,
flag mark,
if there is a so-called notice that they are now saying, they should have produced it at that point of time. Who was stopping them to produce it?
So
at that
they
point of
said
time?
that the council there that time, he had shown the wrong letter. That's what they said.
Again, it is a matter of dispute now because the records were there. No one was stopping him from producing the record, the document. Today, somehow one document now comes and they say that there is a so-called notice now. Because Lordship had given them twice time at the point of time. So therefore, it requires some deliberation actually, because this is not a document that has been newly found. It was already there.
Yes, ma'am.
Who was stopping them from producing it? Is it not therefore prejudicing my case now? Can that opportunity be given to them now? Because they had got ample opportunity at a point of time. So what they have not produced because of their negligence at that point of time, can it be now used against me by way of a review? So this is not a new document. Introduction of a document, if a lordship looks into that aspect, it has to be something that after due diligence, they were not able to find it. But this is the document that they are now saying it's always with them. Then who was stopping them from producing it? It was their delay, their negligence on their part. Can it be now utilized to prejudice me or my case, lordship? Lordship, at best issue a notice and then I can appear with power also in this matter. So without power, I do not want to submit. Because we appeared in the petition, therefore our names are shown. However, the Wakalatnama has not been filed.
There is something wrong with your records.
Therefore, also it's a matter of
Records
dispute.
records are not properly arranged, my lord.
The paginations have all gone for a 6.
But, my lord, from the order sheet, my lord, which was, my lord, put in the past order sheet, my lord, that is reflected.
How do we believe on face value that this is the actual record?
Yeah,
What
my
was
lord,
produced
record
at that
was
point of
written-
time? it
record was
didn't
written
match
in
Anyway,
the-
but what
my lord,
can we
from
do? What
the-
can we
Let
do?
a notice be issued as on date, lordship, I will appear with power.
Oh, well, I think we have already issued notices. Have we issued notice or not?
No, not for the first time.
First time.
Oh, first time.
First, that's right.
Oh, I thought.
Our names are shown because we
Yeah.
appeared in the petition in the cause list. Let the notice be issued.
Not correct. Heard Mr. M. Chetya, Leonard, counsel for the review petitioners, who submits that the impugned order dated 7/6/2024 passed in WPC 1394. No, passed in WPC 1394/2023 should be reviewed inasmuch as the said case had been disposed of on the basis of the letter dated 4/4/2023, which had been sought to be given the color of a show cause notice. First up. Ms. Para, Mr. M. Chetya, the learned counsel for the review petitioner submits that the the learned counsel for the review petitioner who had appeared at the time of disposal of the writ petition had wrongly pointed out the letter dated 4/4/2023 as a show cause notice, while in fact there actually was a show cause notice dated 3/5/23, which should have been brought to the notice of this court. So in this regard, he has relied upon the documents in the official records which he has brought today. Post up. Issue notice, returnable in 4 weeks. Mr. M. Chatria shall take steps. No, the review petition shall take steps for service of notice upon the respondents by registered post with AD. Wait, how many are there?
Hold 6, madam. 6, madam.
By registered post with AD within 3 days. This is the matter after 4 weeks. I thought I'll dispose of all this. I didn't know that it was for the first time. Hurry, mind is in a hurry to finish up this. Yes, item?
Lordship, Mr. Esbora is on late. He's waiting for instruction, so let the matter be sometime maybe.
On the last occasion, on 18/9/2024, the matter was taken up before the Lawazima court.
19/8.
18/9.
18/9.
89, where it was observed, Your Lordship, that services in terms of respondent number 7 and 8 has been completed. For 5 and 6, we were directed to take usual steps, usual process, and Dusty. Usual process we have taken. Dusty, it is yet to be made available to us by the registry. We'll be doing that as and when it is made available. If the Lordship can fix the matter after 4 weeks. 5 and 6 is the only two respondents where the notices have to be served. On So that is my.
You are query for whom?
My lord, I am for respondent date and I seek further time to file affidavit in opposition.
Yeah, for point number 8.
Respondent number 8.
Okay, yeah.
7, 8 is
And you are for madam?
Esbora, GMD.
GMDA.
So you need time to file affidavit?
Yeah.
Okay, right. Mr. M. Sharma appears for the petitioner. What's up? Miss
J. Rajkumari.
J.
Rajkumari.
Rajkumari appears on behalf of Mr. S. Bora, learned counsel for the GMD.
GMDA.
GMDA. She prays for 1 day, 2 days, how much?
3 weeks.
3 weeks. She prays for 3 weeks time to file affidavit on behalf of the GMD. What's up, Mr.
S. N. Gupta.
S. N. Gupta, learned counsel for the respondent number 8 is also granted 3 weeks time to file affidavit in opposition. Full stop. Next. The proceedings of the Lawazima court order dated 18/9/2024 states that
It's a long order. Goes on to the next page.
service in respect of the respondent number 7, service of notice in respect of the respondent number 7 has been completed.
Yes.
Full stop. Further, the petitioner's counsel had been allowed to take fresh steps for service of notice upon the respondent number 5 and 6 through usual process and through dusty. Full stop. Next para. Mr. M. Sharma submits that though notice through usual process has been taken,
Yes.
dusty service of the same has not been done. In view of the fact that the registry has not prepared the notice to be served upon the respondents number 5 and 6 through dusty serve. List the matter after 3 weeks. That's all?
That's all. If the matter can be placed after vacation after 3 weeks, which is after vacation, the date can be.
Date, your date.
I'm grateful, Your Lordship. I think 40.
I'm appearing for the private respondent in this matter. This is a matter of settlement of a market in an extension basis. And I am suffering an interim order against me. This is regarding extension of a market, settlement of a market. Now, Lordship has passed a stay order whereby the extensions have been stayed.
Correct.
So I'm appearing for that beneficiary of that extension order. So my prayer before Lordship is that I concede to the fact that the Panchayat Act does not allow for any such sort of extension. It was a mistake, typographical or for that matter, interpretational mistake of the authorities that they have said it's an extension. Rather, what the government notification says, it has to be a temporary settlement. So if I may just place that, the difficulty is the authorities can give a temporary settlement during this interangam period when the new settlements are not happening because of whatever reasons, court orders or for other reasons. But what happens during that interim period? They can, by way of a notification, which has gone unchallenged till now in this honorable court, temporary settlement. But the authorities, maybe in a layman term, has used the word extension, but the legal connotation of extension is different. What is in existence can only be extended. This is already our settlements are already over. Moreover, Panchayat Act doesn't give any scope for extension. So therefore, if I may just place this, it should have been temporary settlement. The difficulty is, I am otherwise entitled to a settlement in temporary nature in view of this settlement order, in view of this notification. But because the government has used the word set extension, Lordships has stated that.
No, so the only one who can correct the mistake is the government, not you.
But I am suffering and the government, Lordship knows what happened. So because of
It's
this
everywhere.
difficulty,
You see, the problem is the government has not taken a decision on the model NIT to be made till now.
that is true.
The July, August, now 3 months.
Yes.
We are approaching the 3-month mark. I think this case has been listed before on
30.
30.
Series.
How we are trapped is, we have given that kissed money of around 3 lakhs for this 1 month period of settlement that we got. Now that money is again trapped. These are basically economical issues for us. First, they give us.
Maybe we do not know the inside workings.
Can just observe this can just have a look of this document, just for Lordships. Just for that matter, that there is a scope for temporary settlement.
Then let them correct it. If the government has made a mistake, let them correct it. You're not the
They're
government.
not doing it, so I have to take the first seat. This is my difficulty, Lordship. But the fact is, we have to concede. The government also has to concede to this. There is no point of arguing this matter. Extension is not possible.
Then you file a writ petition. Who's barring you from
No,
claiming your rights?
There is a stay order here operating against me.
So what? But
if your
then
Lordships can
you see,
modify
this
the
is not your writ petition. First of all,
Yes.
this is not your writ petition. If you say that you have got a right to continue as per the law, and that government has made a mistake, now that will only be decided in your case.
My endeavor, which would have been also efficacious one, would be to ask your Lordship to observe that there is a notification for temporary settlement. The authorities can therefore take a second look.
This will open up a Pandora's box. Everywhere, all over Assam. Yes, when are you completing your work? Yeah, for that 29/6/2024 order, that notification. When are you going to make the?
My lord, we have informed the government, my lord, that up 39 is the last day. We have to complete before that.
For new NIT.
Model.
Otherwise, we will have to set aside your notification.
Not so serious, my lord. Maybe for the next year, my lord.
For the next year, you can act upon it. But then, wherever the tenders have already been issued, that should be taken to its logical.
Finalization model, my lord. We can go with the process.
Correct. Something has to be done.
Yes.
Anyway, this matter will list it on first. Let that 30th, let those matters be completed. All right. Mr.
MK Hussain.
MK Hussain appears for the petitioner, while Mr. S. Datta appears for the PNRD department. Mr. A. Sharma appears for
Respondent number 6.
respondent number 6. List the matter on first.
Interim was until further order.
Interim order to continue
Was until further order, lordship.
until further, to continue till further order. Acha, have you finished?
Those amount point of research in the meter, I mean books have already been released.
Huh?
those amounts which are in the measurement book, that's already been released.
Okay,
Others, I have filed my appeal because they are disputing that the work is not, they have not conducted the work, so amount will not be released.
Let me file your affidavit.
I will file my appeal.
Mr.
Because
S. Bora,
otherwise the matter relates to rental bill, madam. They cannot-
rental?
Monthly rental. So they
Yes.
cannot dispute that whether it's the work done or not done because there are completion
sure.
certificate issued by them.
Okay, Mr. S. Bora, is granted 3 weeks time to file
Let
affidavit.
it be 2 weeks, my lord.
Well, let it come
3
after-
weeks, 2 weeks is
Same
the
thing.
vacation anyway. He'll get, vacation is 2 weeks anyway.
Yes, 2 weeks. So
Okay, 2 weeks time to file affidavit in the position, this is the matter after 2 weeks.
Very good. Production list for motion item 1.
May I please your lordship?
Yes,
My lord, this is the case, my lord, retail outlet dealership, my lord, to be given by IOCL, Indian Oil Corporation Limited. They made an advertisement on 16, my lord, 28/6/23 for giving an allotting, my lord. Accordingly, he applied for offering some plot of land. I was OBC category, and it was held through conducting lottery.
Huh?
Through lottery, drawal of lottery. On which is held on 12/12/23. Lottery
Yes.
held on 12/12/23. Then, my lord, I was informed that I am selected,
provisionally selected.
provisionally selected. Yes. But then, my lord, I was asked to give some more documents. So accordingly, I have given some more documents of the land and other documents of my identity and all these things, my lord. After submission of same, they have asked me for, my lord, I have given the land taking a lease from what Lokhikantor Sinha for 20 years, my lord. This is permissible. And my lord, they asked me to give next of kin certificate and legal heir certificate of this person. I have answered them. They kindly see, as per the record, he is the only son and is already lands and mutated in his name. It is shown in the mutation and Mabandi records that only son and no other person and all that in his name. There are all 8, 9 because we need only one bigger.
Anyway, next of kin, so you did not give next of kin certificate.
My lord. Then, my lord, what happened in the meantime? Yes, yet I went to the circle office at DC office Karimganj for the same, my lord. They have to, after going there, I have found that they already processed for acquisition of land of this area of this road is under process since 29/5/2023. I have annexed my documents, my lord.
So when did you get to know this?
I have come to know, my lord, later on when they asked me, my lord.
When?
In
Which
the month
date?
of, my lord, in the month of October, sorry, my lord, June or July, my lord, like this, my lord. Exact-
June or July, which which year?
2024, my lord.
In June, July 2024.
Yes, my lord. Then, my lord,
You came to know that,
no, my lord, when they asked me for the letter, then I come to know first.
when was this letter?
Letter was, my lord, on public notice of acquisition, Jamabandi fee receipt, Jamabandi acquisition. My lord, in the month of, in my lord, 19/2/2024, my lord.
19 to 2024. What happened in 19 to 2024?
My lord, they have, my lord, asked me to give some document and I have filed some representation.
In 19 to 2024, did they ask you verbally or by writing?
My lord, they gives only in upload in their website, they so and so, so and so.
So in the email, it was written
No
that,
formal office letter is sent to me.
so in the email,
Yes,
on
my lord.
19 to 2024, you were asked to submit documents.
Yes, my lord.
What documents were you asked to
My
submit?
lord, among other documents, they are satisfied, my lord. Only the next of kin and legal heir.
Next of kin and legal heir of the
Yes.
owner.
Yes, my lord. Of the landholder, my lord, one with the owner, landlord, my lord. From whom I am taken the lease.
Then so you did not submit.
I could not submit because it's under process and when I approached.
Under process?
Yes, my lord, till I applied for. Although there's I have applied for, but.
You have applied for whom? From whom?
Next
From
of
him?
kin, next of kin certificate of the landholder, landlord, my lord. If anyone you please give me.
Then what
Then, my
happened?
lord, they did not process it because they said. What
Who
is the
did
use
not
of-
process?
Deputy Commissioner Revenue Branch Karimganj and Circle Officer Patar Gandhi, they said that, my lord, why to use it? Because it is useless because it is already acquired. So we are not issuing it in they have not issued us. Then we offered I offered a second plot of land.
No. When did you come to know that it was acquired? You're not answering the question directly. I am asking you, when did you get to know that the land was acquired? Going to be acquired? Date. I'm going to write down everything that you say. That's why I want the exact
Yes,
details.
yes. My lord, kindly sit down, page 34, my lord.
Yes.
My lord, prayer for change of land and so and so, my lord. Reference your intimation of selection result of draw via email ID reference number 10 so and so dated 12/12/23, my lord. And I have given the details of with the, my lord, kindly see the my lord, previous page of page, my lord.
So you offered 19 on 19 to 2024, you offered another piece of land.
Yes, my lord, kindly pay.
Now, when was the last date of submission of bid as per the earlier tender?
My lord,
That is finished. That is long finished.
my lord, last was offered to me. Time is that, my lord. Kindly turn to page, my lord, 56 and 57, my lord. My lord, I was required to be submitted by 7/2/24. My lord, the bottom, my lord, last paragraph, my lord. Page 56.
Huh? Page
Page 56, my lord. 56,
You're saying 50, okay, 56.
my lord. Last paragraph, my lord. The requisite documents here are required to be submitted by you as on 7/2/24, my lord.
Mr. Counsel, look, you're not making sense. Where is the last date of submission of your tender? As per the
Oh,
NIT.
my first application, my lord.
Next
Yes,
page.
my lord. Yes, my lord. That is, my lord, on the page, my lord. I'm giving exact, my lord. Page 24, my lord. Last date is 27, 28, my lord. It's very not clear, my lord. I have submitted on the last date, my lord. I'm giving the date, my lord. My lord, 28/8, 23, last date.
Where do you get that?
My lord, page, my lord, 28, my lord. I have submitted on 27, one day before the date. Page 28, I have submitted the money. One amount is 5,000, another amount is for 40,000 for field verification expenses, my lord.
So last date is 28.
28/8, my lord. My lord, then kindly, my lord, turn to
28/8 is last date for submission of tender.
yes. My lord, kindly turn to page 30, my lord.
Last date is 27/9/2023. Your worship finds at page 24.
Page 24.
My
Page 24.
just before the, my lord, second chart. Application for RO dealership along with online payment, etc. should be submitted online by 27/9/2023.
Dated 24. Yes, my lord, sorry, correct. My lord, kindly turn to page, my lord, 30. my
And
lord.
you are provisionally selected
Yes.
on 12/12/23.
Yes.
Now, thereafter, you got to know that your land was being acquired. The land you took only was going to be acquired. Now, where is the provision for giving alternative land?
Yes.
Where is that
Yes.
in terms of the earlier one?
My lord, kindly turn to page 48, my lord.
Yes.
My lord, this is industry guideline on recitement of retail outlet dealership. Recitement, my lord. Then turn to the, my lord, relevant part is 52, my lord, page 52.
Yes.
my lord, two one, my lord, clause 2(1), my lord,
Yes.
clause 2, recitement, change of location of LOI, pre-LOI stage, my lord. There may be,
LOI means what?
my lord, letter of intent, but after finalizing, when they will issue for LOI, before LOI or after LOI, it may be changed, my lord.
No, it says pre-LOI stage, it does, at LOI.
Before finalizing, my lord. My lord, I'm selected provisionally, then I will prove all the documents, then when I will select, finalize, then they will issue LOI, my lord. So pre-LOI and after, post-LOI, permissible.
Yes,
My lord, clause 2(1), my lord.
yes.
There may be situation where the land offered by the applicant meets all the specifications as laid down in the advertisement, and on the basis of which LOI has been issued or proposed to be issued, and the LOI holder or the selected candidate to whom
But you
LOI
see, one thing is that on the basis of which LOI has been issued or proposed to be issued. Okay, then,
my lord, then my lord,
and carry on reading.
yes. Specifically issued LOI holder, the selected candidate to whom LOI is proposed to be issued, would like to offer an alternative land due to whatsoever reason. Such land may be considered by corporation subject to the alternate land meeting all specifications and is within the advertised location stretch. My lord, this opportunity would be available to the LOI holder up to 90 days from the issuance of LOI. The above mentioned opportunity can be availed by selected candidate after clearing CBC/LOI holder only once. My lord, in case the selected candidate after clearing FBC also avails the opportunity to offer alternate land before issuing of LOI, the opportunity will not be available to the candidate post issuance of LOI. Opportunity to offer alternate land also will be available in case of failure of rental negotiation. However, in this stage, LOI holder can offer alternate land within 90 days of failed negotiation. Further, this opportunity will not be available to the LOI holder in case she shall avail the opportunity before issuance of LOI or post issuance of LOI. One-time option, my lord, this is one time to other categories, my lord. My lord, then kindly, my lord, turn to page 30, my lord, kindly.
So is this mandatory that they have to consider, or that is it the discretion whether to accept it or not?
My lord, so far as my understanding, my lord, maybe subject to your lord's opinion, my lord, they have to follow it because anything may happen to one which is beyond my control. My lord.
Supposing there are 5 bidders, do they have to accept all the bidders' lands? What would
No,
happen?
my lord, only one who is selected, my lord, after drawal of lottery, only in case of him, my lord, not of all, my lord. If he is selected, then he question comes, otherwise no question arises, my lord. And there were, my lord, there were 4 candidates, my lord. Their lot was held between 5 candidates, including me, my lord. Now they have done what have done, my lord, kindly pay the last page, my lord, 81. They have info on 20th last, I have come to know from the website of theirs, that they are going to conduct again the drawal on 24th. Among the remaining 4, those earlier failed. Page 81.
First of all, let us see your lease deed.
Lease deed. My lord, this did, my lord, in vernacular, my lord, I could not because of hurry, my lord. Only 20th order, my lord. 21, only yesterday it is done date, my lord. Within one day,
Lease deed is dated?
it is uploaded in their website, my lord. It is available, my lord.
What is the date? What is the date?
Date is, my lord, 25/8/2023. In between, 2 legal notice issued, my lord. 1 reply came also. And I have filed, my lord, 2 representation, my lord. Kindly have a look at page 34, my lord. Your lordship will be strange to see, my lord, this thing, my lord. What happened in this, my lord? Page 34, kindly.
Yes.
I myself has handed over it to. After handing over, they have received it, put seal and signature and date, offering the second plot of land, giving the reasons and all the my lord, acquisition, etc. Then they have, my lord, cut it and hand it over to me there so that I cannot prove it anywhere else. But fortunately, I have it with me. They have put the signature, the receipt, the acknowledgement, the date, then they cut it, my lord. Then they try to totally do it, my lord. This is the situation, my lord. At this stage, only I want that, my lord, tomorrow that third party may not interest may not be taken, my lord. It will be another round of litigation thereafter, my lord. Let them come with a reply, my lord, till then, my lord, only. And my lord, acquisition date, my lord, kindly see at page, my lord, at page 30, my lord.
Who was the leaseholder, the landholder?
Landholder,
What is his name?
Yes, Lokhikanto Sinha, my lord.
Huh?
Lokhikanto Sinha. My lord, this land document is at page number, my lord, Jamabandi page, my lord, at page 32, my lord.
Sinha. What is his name? Sinha.
Lokhikanto Sinha, my lord. Son of late Mohendra Kumar Sinha. Page 32 and 33, my lord. These two, my lord, of the entire land of Lokhikanto Sinha, my lord, there are around 7-8 bighas.
Come to page 56.
My lord.
Please read page 56.
Yes, my lord. My lord, RO dealership, sub RO dealership at so and so OBC category. You had submitted application for RO dealership under group so and so, declaring land ownership of land held at late Mohendra Kumar Sinha for the Khatsa Khatuni survey number so and so, opposite City Daba so and so Vatarkandi bypass. My lord. You are declared selected for the aforesaid location based on the information given in your application form under group 1. By system generated email on 12/12, you were asked to submit the documents in support of your application norm in form, including the land documents. However, you had not submitted any documents and another opportunity was given to you by email so and so. In response, you uploaded only 2 pages of lease deed executed between Sri Pratap Sinha and Sri Lokhikanto Sinha, son of late Mohendra Kumar Sinha, and no date of execution. It is absolutely false, my lord, incorrect. No date of execution was mentioned on the uploaded lease deed. As such, there was a discrepancy in the information given to your application form and the land documents submitted by him. Accordingly, under rectifiable deficiency, you were asked to upload clear copy of land documents in support of ownership page lease rights in line with the application. The requisite documents were required to be submitted by you as on 7/2/24. However, neither you provided any document nor submitted any relevant clarifications in response to our queries. Therefore, your candidature is rejected and you are intimated regarding the same by email dated 18/6/24, wherein you were also advised to submit a representation with 10 days by 28/6/24.
So your candidature was rejected?
Yes, my lord.
On 18/6/2024?
Yes.
Now you have come last date, last.
No, my lord, no, my lord. I was transacting thereafter, kind of legal notice has gone, my lord. Another representation. They were saying that we will consider. Suddenly, on just my lord, day before yesterday, on last Friday, I have come to see in the internet. Even I have communicated that among the remaining four, re-drawal will be conducted on 24th, my lord. And then, my lord, I come to the alert, my lord, immediately at the earliest possible, my lord, I filed it, my lord. On the next day, within 24 hours.
Please read.
Accordingly, you submitted the representation by email so and so, wherein you have made the following submissions. A notification was published in Gazette of India, New Delhi on Friday, 16/2/24, whereby a leasehold land and other nearby land was notified for acquisition for construction of 4-lane under Brahmaputra Bharatmala project. Thus, leasehold land as shown to me become fruitless. I have also submitted the documents of my relatives' land as per Appendix 3. This is second, my lord, proposal of the land, my lord, in the same locality, which is out of the notified land. My lord, this is a mistaken meaning out within the land, contiguous adjacent, my lord. Actually, my lord, I was asked to submit lease deed and other documents of landlord Lokhikanto Sinha in respect of the said land, where already the land is notified for constructing highway within next few months, and such said land and the relevant land deed became infructuous and carried no value, but most unfortunately solely of the ground that I failed to produce the lease deed on next to kin certificate of said Lokhikanto Singh. My candidature was rejected. Therefore, I would request you to cause a local spot verification by your office staff and examine the land documents of the land, which is out of the notified area. My lord, actually out of the he meant within, my lord. My lord, actually is contiguous land, my lord. The third land I offered, my lord. The second land I offered, my lord. In this regard, you have also sent a legal notice on 3/7/24 from your advocate so and so, Law Court, reiterating the aforesaid point and also attaching the gazette notification for land acquisition of the land offered by you. We have gone through your representation carefully and verified your application and documents submitted in your portal based on the aforesaid. Your representation is not acceptable for reasons given below. By your application number so you have claimed and under group 1 category with ownership of late Mahendra Kumar Singh. Further, based on the uploaded documents, land in the name of late Mahendra Kumar Sinha, where the registered lease is executed between Sri Pratap Sinha and Sri Lakshikanto Sinha, son of late Mahendra Kumar Sinha. No legal heir certificate of next to kin certificate of late Mahendra Kumar Sinha was uploaded to ascertain rights over the property by Sri Lakshikanto Sinha. As claimed in notice dated 3/7/24, records of offered land mutated in favor of Sri Lakshikanto Sinha were not uploaded. Opportunity was given to upload the correct certified documents by mail dated 17/1/24 was provided to you for substantiating your claim to land applied in the application. However, you did not upload requisite documents for the land as applied in the application. Surprisingly, additional documents pertaining to another property were uploaded. That is, my lord, I actually really prayed for the second plot I am given, my lord. As such, you offered an alternate land which was not mentioned by you in the application form. My lord, how can I mention in application form, my lord? It is development of.
It seems your case is starting to fall flat.
My lord, as per extent guidelines, no change in Khasta number, Khatuni number, survey number, so and so is given, my lord. My lord, Khatuni number, Khasta number cannot be there because, my lord, the gazette notification never comes with Dag number and Phata number, which is running in Assam, my lord. All India, they makes a survey, there is survey number, their number, my lord. No Khatian number and Khorsa number in there in Assam, my lord, now presently prevailing, my lord. There, it may also be noted that there is provision in the extent dealership procure for providing alternate land for impugn location. It may also be noted that upon the email dated 7, you had the time until 7/2 to relevant documents in order to establish the title and ownership of Sri Lakshikanto Sinha. In fact, you submitted the documents for alternate land before 2/7/24, where the notification for acquisition of offered and land was published in 16/2. It is clear, my lord, that answer I am giving you to your lordship, my lord. Kindly have a look at page 30 of that answer is there, my lord.
Please carry on, finish reading this.
Yes.
Page 58.
My lord, in fact, you submitted documents for alternate land before 2/7/24, where the notification for acquisition of offered land was published on 16/2/24. It is clear that you had not uploaded documents of the offered land on the basis of the notification, but as an excuse in order to justify the submission in an alternate land, as you could not establish the ownership of Sri Lakshikanto Sinha for the offered land. In fact, your candidature was rejected much later on 18/6/2024, and only upon your rejection as an afterthought, you informed the corporation through the representation that the offered land has been earmarked for acquisition. In view of the aforesaid, the application made for the subject location could not be considered, and your representation dated 28/6/24 is disposed of accordingly. The corporation shall proceed further with the selection process for the aforesaid location. My lord, kindly come to page 31st, my lord. That all answer I should satisfy your lordship.
So this page 56 is not under challenge, correct? Page 56 is not under challenge.
It's not under. My lord, yes, my lord. I want only the stay of the, my lord, proceeding which is going on further.
You don't challenge the important documents, then you don't challenge it. Nice story, but then you have forgotten to challenge it.
My lord, yes, I will, prayer should have been there, my lord, on the safe, my lord.
And this was issued in July. Now it's.
My lord, thereafter I have contacted with them and also issued, kindly see, my lord.
After this document, 22nd July, what document have you submitted to them? Let us see.
My first I have given the note, my lord, representation on 19/2, my lord. Then
Mr. Counsel, please understand the question.
My lord.
My question is very simple. After 22nd July 2024, did you submit any representation to the authorities?
Yes, my lord.
Where?
My lord, One is second petition.
69, page 75.
Page 6. My lord, I have said my lord legal notice, my lord.
Yes, let us see what you have said here.
Kindly see, my lord. Page 75, my lord.
Yes.
My lord, under inspection, my lord, I the undersigned on behalf of Sris Pratap Sinha, son of late so and so, bring to your notice the following facts for your perusal and necessary response from your end. That in response to the advertisement dated 28/6/23 on the caption subject above, my client had applied for the same on 27/8/23, annexing requisite documents, including land documents and paying necessary fees. That after completion of necessary verification and after following due process, my client was intimated from your end on 18/6 that this time his name is selected for the subject arrow. Thereafter, he is asked from your end to produce legal heir next of kin certificate of the proposed landholder. Though there was no provision in the advertisement to produce such certificate. More so, while the sole owner of the proposed land is the signatory of the lease deed and he himself is alive. In spite of that,
Who is
my
the sole owner that time? Who was the sole owner?
my lord, with whom I have executed the lease
No,
deed,
no. Yeah, who is the sole owner of the land?
Lokikanta Sinha,
Lokikanta Sinha.
with whom I have leased it.
Just show me the lease deed. Just show me the lease deed that you have. Show me the
Yeah.
Just see who has executed it. Okay. Lokikanta Sinha. Right, huh?
My lord, land record is at page, my lord. This connection land record is at page.
What about this Mahendra Kumar Sinha?
Mahendra Kumar, my father, he late, my lord. It is in the Mabandi record, it is there, my lord.
Mahendra Kumar Sinha is not your father. He is the father of Lokikanta Sinha.
Yes, no, not my lord, Lokiranto. Yes, I'm saying Lokiranto is the my lord land holder.
And
With whom I am in lease.
who is the landowner?
Yes, but Lokiranto Sinha.
Lokikanta, not
Yes.
Mahendra Kumar Sinha.
No, Mahendra Kumar died long back, his father, Lokiranto's father. Kindly turn to page, my lord, page 20 to 33, it will be clear.
Okay, anyway, continue. Let us see.
Mabandi record, kindly see, my lord, page 32, my lord. Page the.
No, carry on with your legal
Only,
notice.
my lord, legal notice, yes. He and himself is alive. In spite of that, my client was trying to get the same issued from the authority concerned, but it is known to you that and all that it is a long and time-consuming matter. That in the meantime, a notification was published in the Gazette of India, New Delhi, February 16/24, notifying for acquisition of land for enlargement of the existing road into.
So 16 to 24.
Yes.
Acquisition proceedings were initiated.
No, my lord, it is almost concluded. Kindly see it.
No, it says here.
My lord, your lord.
Notifying for acquisition of land.
Yes, my lord. But one
So
thing.
notifying, so on 16/2, it is not concluded, it just started.
My lord, kindly see what happened these days, my lord. Because of, to make it short, my lord, they have started in the month of May 2023, my lord. I have NS documents, my lord. And my lord, what happened, my lord? They used to, even the tender is made, my lord, on 5/1/24. Kindly see the tender, NIT, my lord. It is under process in this way to pay the compensate the people, and the other way, the NIT is issued. This is under process, my lord. Kindly turn to page.
Yes, Mr. Sadari, give this back to me.
My lord, kindly see page 42, my lord. Kindly have a look. 42. See, this is NIT is issued, my lord, on this same letter. Before this gazette notification, before that, my lord, process started in 23/5. I have NS page 30. Notification, public notification given by Deputy Commissioner and my lord, the Deputy Secretary Land Revenue, my lord, of Assam.
Anyway, yes.
My lord, the prayer made in the writ petition, if your lordship comes to the prayer portion of page 15, he is challenging rejection order dated 18/6/2024. And 18/6/2024, that document is not before your lordship.
Correct.
Now, my lord, against this 18/6/2024 rejection order, he filed a representation. And that was, my lord, that opportunity was given to the, my lord, petitioner. So after that, my lord, your lordship has read the order at, my lord, page 56, by which, my lord, his representation was considered and a speaking order was passed. That is not under challenge with your lordship. Now, my lord, he speaks of, my lord, recitement.
Hmm.
Recitement, for that, my lord, he has been relying on a document. My lord, the notification, the guidelines, guidelines your lordship will find. Please, with us. Page 48.
48, yes, 48.
So, my lord, recitement will occur when, that will be clear, my lord, from the reading of, my lord, the clause my learned friend was relying, clause 2.1 at page 52. May I read that, my lord? Because recitement happens when, my lord, a letter of allotment is issued, or, my lord, proposed to be issued. That is clear, my lord. Your lordship will kindly read industry guidelines on recitement, clause 2, recitement, change of location at LOI pre-LOI stage. Recitement at LOI pre-LOI stage shall be allowed in the following cases only. 2.1, my learned friend is relying. There may be a situation where the land offered by the applicant meets all the specifications. So this is important, my lord. Meets all the specifications as laid down in the advertisement and on the basis of which the LOI has been issued or proposed to be issued. Here is a case, my lord.
So it has not been.
It does not fulfill, therefore the question of, my lord,
Recitement does not arise.
does not arise at all. And, my lord, his rejection was not based on the, my lord, the acquisition. His application itself, my lord, he did not upload the documents. We had given him opportunities time and again. He could not upload the documents. Had he, my lord, filed those documents and the authorities found that, my lord, it was proper and acceptable, then only perhaps, my lord, offering a, my lord, alternative land could have arisen.
Correct.
And, my lord, this rejection of the, my lord, his representation.
But he was provisionally accepted.
It was provisionally accepted because, my lord, on the basis of the, my lord,
Online application.
Yes, online application, the lottery is held. Thereafter, we verify the documents, we ask the documents. He could not place the documents before the authority. Therefore, my lord, this acquisition, this recitement, these are not questions, my lord, which falls for consideration before lordship in this case. And the rejection was in June. The second, my lord,
No, that is to justify why his second site should be considered.
My lord, kindly have a look at page, my lord, my lord, page 30.
13.
Page 30, my lord.
Yes.
This is the first requisition, my lord, for order notification of the land 29/5/23.
No, Mr. Council, that's not the
And
issue.
my lord, he's saying, my lord, 1120 saying, I have not submitted documents, my lord. I have submitted document online. My lord.
You go to.
He was asking only for legal hair and next of kin, which is not possible to get, my lord, issued on in that time, my lord. Because the authority is not issuing because they are saying it is under requisition of part 2. They are not issuing. I have mentioned it in my letter, in my representation, in my legal notice. That it is not being issued because it is already acquired. My lord, even NIT is issued, my lord, on 5/1/2024, my lord. So they are not issuing the same, neither the next of kin nor the LOI, my lord. And I have mentioned it, my lord. Lakshikanto himself, by record, by annexer, my lord, Jamabandi, my lord, is clear that he is the only owner of the land, and even the next of kin is not required, maybe, my
You
lord.
see, they are not bound to accept the alternative land.
My lord, this is provided, my lord, in this year, my lord.
They're not bound.
Industry, my lord, recitement.
They can decide whether to accept your land or not. There is no hard and fast rule that they have to accept your alternative land.
My lord, acquisition is done, my lord, before that, my lord. Neither the authority was aware, not I was aware. My lord, not that none of them were aware of. It is started in 25.
I'll tell you what I can do. What I can do is I can issue notice, or I can dismiss and you can go to division bench.
My lord, my lord, subject to outcome, my lord, at least, my lord. Otherwise, it will be, my lord.
No case, no case.
My lord.
No case. Sorry. Heard. Mr.
My lord, kindly have a look at page 33. My lord, kindly have a look at the
Learned
strategy.
counsel, please do not disturb. I've heard enough. I've heard you for 40 minutes. Heard Mr. A.K. Talukdar, learned counsel for the petitioner, who submits that in response to an advertisement dated 28/6/2023 issued by the IOCL, Indian Oil Corporation Limited, bracket IOCL for short, inviting applications for retail outlet dealership for petroleum. Where is that NIT?
My lord, actually not mentioned exactly my lord, it's normally petroleum diesel.
Then you have said this in your
Yes, my lord, that is, we are told like this. my lord.
retail outlet
We are told.
dealership at Patharkandi Bypass Road, Karimganj, the petitioner submitted an application by offering a plot of land which was leased to him for 20 years by one Shri Lakshikanta Singha, son of late Mahendra Kumar Singha. In the draw of lots held on 12/12/2023, the petitioner was given provisional allotment. The petitioner was provisionally selected for the retail outlet dealership. The IOCL thereafter requested the petitioner to submit further documents with respect to the offered plot of land for the retail outlet. Next para. The petitioner's counsel submits that in the meantime, the petitioner came to know that the district commissioner, Karimganj, had started the process of acquiring the land, acquiring the petitioner's offered plot of land for setting up the retail outlet dealership. And in that view of the matter, the petitioner had submitted an alternative plot of land for the retail outlet dealership in terms of clause 2 of the
Industry guidelines.
industry guidelines on resitement of retail outlet dealerships. RESITEMENT, resitement. Next para. The petitioner's counsel submits that a second draw of lots is to be held tomorrow, and unless the petitioner is no, before that, you're right. The petitioner's counsel submits that in the meantime, the petitioner's in the meantime, the respondents had issued a letter dated 18/6/2024 informing him that his candidature for the retail outlet dealership was cancelled/rejected due to non-submission of documents in respect of the earlier land offered by him. Pusta. Next paragraph. The petitioner's counsel submits that when an alternative land has been provided by the petitioner, comma, as the earlier land was identified for acquisition by the state government, comma, by state government,
Will the central government?
by the government, it says by the government, comma. The IOCL had to consider the case of the petitioner afresh in the draw of lots to be held on
My lord, my prayer was actually for alternative land, my lord,
24, huh?
for accepting my alternative land.
Correct, that's what I said, no? That's what I said, I think.
Yes.
24/9/2024. Full stop. Mr. M.K. Chaudhary, the learned senior counsel appearing for the IOCL, assisted by Mr. M. Huh? P. I was thinking M. Bhardwaj. P. Bhardwaj submits that the question of considering the petitioner's alternative site does not arise in terms of clause 2 of the industry guidelines on resitement of retail outlet dealerships, inasmuch as the petitioner's earlier offered land did not meet the specifications required by the IOCL. He submits that that draw of lots is held on the basis of the information provided by the bidders in the online portal. Full stop. Once a bidder is provisionally selected, comma, the bidder is to provide the necessary documents in support of his uploaded documents. Though opportunity had been given to the petitioner to provide the documents and to upload correct/rectified documents, comma, the same was not done by the petitioner. As such, the question of application of clause 2 and 2.1 of the industry guidelines on resitement of retail outlet dealerships is not applicable to the case of the petition. That's all. I have heard the counsel for
And that, my lord, the order, subsequent order is
Ah.
from the challenge.
Full stop. He further submits that though the petitioner has made a challenge to the letter dated 18/6/2024, whereby his candidature has been rejected by the IOCL, comma, the same has not been annexed to the writ petition. The representation made by the petitioner against the rejection letter dated 18/6/2024 had been rejected by
Page 56.
by the IOCL by letter dated 22/7/2024.
By
Who's that?
speaking order.
Huh?
By a recent order. By a
But that's okay. However, the same has not been put to challenge by the petition. Next, I have heard the learned counsel for the purpose. As rightly pointed out by the senior counsel for the petitioner, respondent, IOCL, the petitioner has not annexed a copy of the letter dated 18/6/2024, by which the petitioner's candidature for the retail outlet dealership has been rejected. Full stop. A perusal of the letter dated 22/7/2024 issued by the IOCL against the representation made by the petitioner. Now, in relation to the representation made by the petitioner, in relation to the representation made by the petitioner against the impugned letter dated 18/6/2020 shows that a reasoned order has been given by the IOCL for rejection of the petitioner's candidature. The letter dated 22/7/2024, which has rejected the petitioner's representation, and the petitioner's legal notice dated 3/7/2024. No, don't say that. Just say the representation dated 28/6/2024 shows that the petitioner had not submitted documents in support of his uploaded documents. Full stop. The rejection of the petitioner's representation dated 28/6/2024 against the impugned letter dated 25/8/20, no, the impugned letter dated 18/6/2024. Is reproduced herein below as follows. Page 57 from here. To here, okay. Full stop. Next, clause 2 and 2.1 of the industry guidelines on resitement of retail outlet dealerships states as follows. Page 52. Here to here. Full stop. A perusal of the above clause 2 and 2.1 shows that where land offered by an applicant meets all the specifications as laid down in the advertisement, and on the basis of which LOI has been issued or proposed to be issued, and the LOI holder or the selected candidate to whom LOI is proposed to be issued would like to offer an alternative land, due to whatever reason, such land may be considered by the corporation subject to the alternate land meeting all specifications and is within the advertised location/stretch. Full stop. In the present case, the letter, the letter dated 22/7/2024 issued by the IOCL clearly shows that the land offered by the petitioner earlier did not meet all the specifications as laid down in the advertisement, comma, as the petitioner could not give supporting documents in respect of the said offered land. As such, the question of the petitioner submitting an alternative site does not arise. Second, full stop. Secondly, even if the petitioner was eligible to have offered an alternative site, comma, the acceptance of the same would be within the discretionary power of the IOC. Keeping in view that the same would have to meet all specifications of the advertisement issued by the IOC. Full stop. It may also be stated that is the representation here 28.6? 28.6. 28.6. 343. Huh? 343. 343. No, forget that. Forget that. Full stop. On considering the fact that the petitioner's offer of an alternative land for the retail outlet dealership does not meet the requirements of clause 2 and clause 2.1 of the industry guidelines on resitement of retail outlet dealership, and as there has been no challenge to the representation to the letter dated 22/7/2024, which is a reasoned order made by the IOCM, this court does not find any ground to exercise its discretion in the present case. The writ petition is accordingly dismissed.
Notice, if lordship. It will go, your lordship.
Huh?
Notice will go, my lord.
No, not at all. I'm giving you a chance to go directly to division bench. Then you can apply there.
My lord, second plot of land was not, my lord, even seen and checked, my lord.
Huh?
But second plot of land, there is no question, my lord, that did not meet specification. It is not even seen, my lord.
No, Mr. Counsel, the question of second plot of land being considered by them will only come into consideration when your first plot of land meets the specification required. There is nothing, actually, one more thing, you're right. It may also be noted here that there was no decision made by the IOCM with regard to offering the LOI to the petition pursuant to the advertisement dated so. No point keeping it pending in these cases.
Actually, my lord, they asked only us the next of kin and legal heir. But the remaining things was okay, but only this could not be obtained at this time.